Yes. You're for the petitioner. All right, as paid for by the learned counsel for the petition and not objected to by the other side, matter stands adjourned for 2 weeks. Hmm. 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 How much time? 3 weeks. As paid for by the learned counsel for the petitioner, 3 weeks time is granted for filing rejoinder affidavit. Yes. 34. Why? It's coming from Tilcher. All right. WPC 135023. 5th of June. 5th of June. Did come on 4th. Item 15. As paid for by Mr. A.B. Prokastya, learned counsel for the petitioners. Released the matter on 4th of June 2025, along with WPC number 1350 of 2023. In which case? Okay, no problem. Yes. Two weeks for what? As paid for by Mr. B. Prokastya, learned counsel for the petitioner, matter stands adjourned for 2 weeks to enable him obtain instructions from his client. Yes. Hmm. 2:30. No, you wait now. We'll take up after some time. Well, I'll be taking up order matters first. Only thereafter we'll take up admission. Yes. Item 3. Item 3. You're for the respondent. For the respondent. Why do you want type? Huh? No, you want adjournment. On what ground? Okay, Mr. S.P. Das, learned counsel for the petitioner, submits that he needs some more time to prepare that matter. Mr. As paid for matter stands adjourned for 2 weeks. No, will not fix a date. Why? You're not ready today. Why should we fix a date? Okay, list on 9th of June. All right. Which one? 30. 38. MJ Kadir. How it has become infructuous? What is a good name? Sorry? A.K. Hanna. Spelling? H.A. Halal. Double N-A-N. Okay, it's okay. Mr. H.A. Hanan. A.K. Hanan. Learned counsel submits that he has been instructed by Mr. M.J. Kadir, learned counsel for the petitioner, that the writ petition has become infructuous. Considering the submission made, the petition stands dismissed as infructuous. All right. Item number 2. Item number 2. You want some time for filing reply? And who has filed this IA? IA. What is this IA?
Reply filed by the respondent number 1, Commissioner and Secretary Dr. Bashar.
No, today the matter is IA is listed. You don't know what you're praying for. Why should we adjourn it? You stick around, we'll see. When the matter is called, you make your prayer. Please call the items.
My lord, in this matter, my lord, I am appearing for a respondent number 5, private respondent, my lord, and I have been retired from service, my lord. And the challenge was to the promotion of to the post of principal. And on the last occasion, the petitioner's counsel paid for time to receive instruction. My lord,
That was last year.
yes, my lord, when the matter is.
What to do? What is the matter regarding?
Regarding, my lord, the subject matter was, my lord, my appointment to the post of principal of this secondary school, my lord.
Your appointment is challenged.
Yes, was under challenge, and in the meantime, my lord, I have been retired from that post, my lord.
When?
My lord, last year, my lord. Last year, October, my lord.
Do you have the date?
My lord, that, my lord.
Respondent number 5.
Respondent number 5, my lord.
Please write down none appears for the petitioner when that is called. Mr. Your good name?
RM Deka.
Mr. RM Deka, learned counsel appears for respondent number 5 and submits that the appointment of the respondent number 5
Respondent number 5 to the post of principal, my lord.
in the post of principal has been put to challenge by the petitioner. But the respondent number 5 has since retired from service in the month of October 2024. Next paragraph. It appears that the petition is no longer interested in the matter. In view of above, the matter stands dismissed as infructuous, dismissed as for non-prosecution.
Deeply obliged.
Yes, where is that counsel? No, 37, okay. Who's that counsel who came from Calcutta?
58.
58, oh, that's it. None appears for the petitioner when the matter is called. Matter stands dismissed for non-prosecution. Same order. Dismiss for default.
In this case, my lord, I was supposed to take fresh step, my lord, on the respondent number 5, 6, 7, my lord. I was supposed to take fresh step, my lord, on the respondent number 567, private respondent, my lord. I will take by this within the course of the day, my lord.
5 and 6.
567,
7 also.
my lord. I will take
7 by which order?
Actually, earlier, my lord, the steps were taken, my lord. 5 and 6, they did not appear, my lord. Accordingly, 5 and 6 were directed to take steps. So I'll take only 5 and 6, my lord. And since 7 is also not represented, that's why.
You take 7 also.
My lord.
Your good name?
Yes, okay.
On the prayer of Mr. S. Hawk, learned counsel for the petitioner, 3 days time is granted to take steps for service of notice upon respondent number 5, 6, and 7 by registered post with AD due.
My lord.
List again after 3 weeks.
Obliged.
As per Lojima order, Lordship, the respondent number 7 notice has been completed. Lordship. So, Mr. Miller for admission.
Lawazima order?
8/5/2024.
Respondents,
I am for the department, Lordship.
have you filed affidavit?
Lordship, we have not yet filed. We have received some instruction, but that complete instruction is still awaited, Lordship. I will file.
When?
Lordship, file after, fixed after 3 weeks, Lordship.
And what about private respondent number 6?
Private respondent, I think service 6.
So service is complete. No one is appearing over. None appears. Please write like this. Parties are represented by the respective councils except for respondent number 6. On the request of Mr. P. N. Sharma, learned standing counsel. Which department?
Elementary Education Department. Lordship.
Elementary Education Department. Further 3 weeks time is granted to receive instructions and to file the counter affidavit. List after 3 weeks. None appears for the petitioner when the matter is called. Matter stands dismissed for non-prosecution.
I'm for the department of secondary education.
Mr.
FMT 64,
SMT Chisti appears for the
secondary education.
secondary education department. Mr. A.U. Ahmed,
No.
he has not come.
No, Lord.
42, I am here.
43.
Hmm?
43. 43.
42, I am here.
42, I am dismissed it.
I am sorry, my lord.
What happened now?
Because my step has been taken. We have taken justice service also. I filed a visit. Regarding respondent, private respondent.
What you stated and what is reported in the Dusty Lawazima is not correct. It's not same.
Because in justice, he refused to accept the notice.
No, which respondent did you serve notice?
Uh,
Please give me back the file. You made some submission before the court that you have made Dusty steps, but the office has given something else report. It does not tally. Your submission before the court was that you have filed Dusty.
Yes.
You have served Dusty's notice
Yes.
to which respondent? Respondent number 5.
No, no, my. Respondent number 12.
It says 5.
Respondent 12 is the party have taken justice service, but he has refused to accept the notice.
Huh?
He is refused to accept. I filed a video. Page 93, madam.
He refused to accept.
You will also get page 96 of my page 96. There is the service notice. We went there, the respondent number 12 refused to accept notice. This court asked me to file affidavit, I filed it. Informing that he is refused. But I got information that in usual process service notice, he received a notice.
No, which page number? Your
Page
affidavit?
number, my affidavit is page number 93.
'93 is affidavit in opposition of respondent number 10.
Affidavit filed by the petitioner with regard to service of notice.
No. 93 is something else.
Then there,
Where is your affidavit?
I filed affidavit, my lord. On 21st November 2024.
Okay. Where is the refusal?
Your lordship kindly see, I made a statement on
Paragraph.
paragraph, my lord. Paragraph 2, my lord. But the respondent number 12 refused to accept the notice from the public. Paragraph 2, last verse. But the respondent number 12 refused to accept the notice from the deponent. Then, my lord, I got just information that in usual process service, he accept the notice.
How?
We also take the service on usual process.
So where's the report on that?
My every notice office note.
Huh?
I am not checked the office note whether that debit has been written or not.
You check up?
What?
This item 42 order you cancel, okay? Dismiss कर दिया. You are Mr. J. Ahmed, isn't
Yes,
it?
ma'am.
Please check up. Please write down Mr. J. Ahmed, learned counsel for the petitioner, submits that the petitioner has served notice to has tried to serve notice to respondent number 12 by way of Dusty.
Right.
On 7/11/2024. At about 7 a.m. at his residence at Kolohi Kash, but the respondent number 12 refused to accept the notice. He submits that the petitioner has filed an affidavit to that effect on 22/11/2024. The learned counsel also submits that
That's I got information. Right?
respondent number 5 indicated in the order dated 22/11/2024 in fact should read as respondent number 12 instead. Stop. Yes.
Here notice not there.
Then
Office note is not there.
from where you're saying?
Just my client informed me that Zarikarak went to his school.
Okay, now as per the usual step, how do we verify that notice has received or not?
Not necessarily because I submitted my lord affidavit indicating that he refused to accept notice.
I'm not
My
on
visit
that.
complete,
Mr. Ahmed, please try to understand.
My lord.
What I'm saying is that notice by usual service. How do you get the acknowledgement? By usual service.
Then it will be wait for service.
No, who will report back?
The Jarikara, the civil court.
Okay.
It-
Next para. No, next para, same para. The learned counsel also submits that notice was also sent to respondent number 12 by usual service. And he therefore submits that service report may be awaited. Considering the submission, list the matter again after 2 weeks. Registry shall put up a report regarding notice being served by way of usual process by the next date. All right.
April to sir.
Here, Lordship, the order has been partially complied with, Lordship. Here in the order, there are two directions, Lordship. One was to conclude the DP against the petitioner, and second was to consider the case of the petitioner for volunteer retirement, Lordship.
Okay, let's see the order.
Lordship, page 14, page 16 is the operative part, Lordship.
To complete the department proceedings pending against the petitioner within a period of 3 months.
Lordship, that has been
Then
complied.
thereafter, respondent shall consider the petition's representation of voluntary retirement and shall take a decision within
A period of
1 month.
Yes. Here, Lordship, now
DP is completed,
DP has been concluded, Lordship. As per-
concluded. What was the conclusion?
Lordship, here I have the report, Lordship. If Lordship will, there's a speaking order passed regarding the DP or Lordship.
What does it say? Just tell me.
Yes, Lordship, here in the period of unauthorized absence of 414 days being suspended and the period of unauthorized absence till the date of VRS will be effective as may be decided upon by the government. May be treated as no work, no pay. The period may be regularized by way of extraordinary leave, subject to concurrence of Finance Department and submission of all supporting documents by the doctor concerned.
What is that document?
Lordship, these documents are something regarding the service report.
What is that document which you're reading?
This is a speaking order, Lordship.
Speaking order dated
24/2025, Lordship.
24/10,
24 April, 20/04/2025, Lordship.
20th of
20th of April.
April 25.
Yes, Lordship.
Now, what remains?
Now, consideration of the petitioner's case for volunteer retirement, the retirement.
May I submit?
Yes.
Lordship, after 25 years, they have completed a DP, Lordship. And case was decided 2017. This is 6 years.
Yes.
They have completed a DP after the order after 6 years, Lordship.
Hmm.
And DP is completed after 25 years. I was suspended before 25 years, Lordship. Now, one part, the major part is to decide our VRS, Lordship. I have already retirement is over, Lordship. Now they have till date, last occasion, they have took time to comply the order, Lordship. Till date not comply.
Lordship, I'm just seeking for 2 weeks time. In the meantime, we'll be now only the volunteer retirement, whether or not he
You
retires.
decide.
Yes, Lordship. Only 2 weeks time, Lordship.
We'll fix a date.
Yes, Lordship.
Yes.
2 weeks time, maybe.
Mr. A. Chaliha, learned counsel for respondent number,
Lordship, here one only, Lordship.
respondent number 1
Yes, Lordship. He is
Stop.
not holding the post right now, Lordship.
submits that the direction of this court has been partially complied with the passing of the speaking order dated 24/2025. Stop. He submits that now
The issue,
the decision with regard to
volunteer retirement.
voluntary retirement of the petitioner remains to be taken. And he prays that he may be given 2 weeks' time to come back with the up-to-date instruction. Stop. The learned counsel for the petitioner, Mr. A.U. Ahmed, submits that the respondents have taken a very long time to comply with the court's direction. and therefore a specific direction may be passed to complete the process within a time frame. Stop. However, considering Mr. A. Chaliha's submission seeking 2 weeks' time, this court deems it proper to grant further 2 weeks' time. List the matter again on 13/6/2025. Mr. Chaliha shall come up with the up-to-date instructions by then. Yes. Yes.
Praying for little accommodation, as of for the day only, I could not refer the matter actually. They have to.
As paid for by the learned counsel for the petitioner, matter stands passed over for the day.
Highly obvious.
As per Lajima Court's order dated 6/12/2024, service upon respondent 3 has been complete, my lord.
Okay, then on perusal of the Lawazima Court's order dated 6/12/2024, notice is deemed to be complete upon respondent number 3. However, as no one appears for respondent number 3 today, let the matter be listed again after 2 weeks. In the meantime, respondents will be at liberty to file their counter affidavit.
That may be fixed, my lord, if possible.
Okay, after in the second, third week, June. 18/6, list the matter on 18/6. Museum Romero.
May it please, my lord. My lord, we have not been able to file amended cause title because we have not been able to contact the petitioners. My lord, may grant some more time for us to contact the petitioners so that we can file the required amended cause title.
How much time should you require?
My lord, in 4 weeks would be,
Why?
my lord, so that we can contact and then file everything before the returnable.
Your good name?
P. Devi, my lord.
P.
Devi.
Ms. P. Devi, learned counsel for the petitioner, submits that she's not been able to contact her client and prays for further 4 weeks' time to submit the amended cause title. Considering the prayer, 4 weeks' time is granted as prayed for.
My lord, interim earlier may be continued.
What interim?
My lord, there is an interim order passed in the first date, my lord.
I'll vacate this interim order if you do not file within next 4 weeks.
Yes, yes.
Interim order passed earlier shall continue till the next date of listing. List the matter on so and so. Give a date, 4 weeks. Please file the thing. Oh, okay.
Yes, my lord.
List again on 16/7. Okay. Okay.
May I please, there also, it's a contempt application, my lord. On the last occasion, respondent has sought time to, my lord, take the instruction.
My lord, in this matter, hearing will be held tomorrow, my lord. And the verification process is going on, my lord. So, my lord, some time may be required, my lord, yeah.
What is the direction?
Direction is to payment one advance increment after
verification.
acquiring B.Ed degree, my lord.
Page, order?
My lord, page 16, my lord, para 5, my lord.
Petition is working as?
My lord, assistant teacher, my lord.
Please write down. Direction of this court was to grant one additional increment to the petitioner for obtaining B.Ed degree. Mr.
U. Sharma.
U. Sharma,
On behalf of my lord, SMT 60, for respondent number 1 and 2.
learned counsel appearing on behalf of Mr. SNT Chisti. Learned counsel for respondent numbers
1 and 2, my lord.
1 and 2 submits that hearing will be conducted tomorrow.
Tomorrow, yes.
In view of above, list the matter again on.
Next week, my lord.
After 2 weeks, my lord.
My lord,
In the
it is
meantime,
my lord,
all the documents will
2023
verify.
matter, my lord, 2023 order, my lord, since 2019, she is seeking one advance increment, my lord. However, my lord,
We'll give a date, just a minute.
my lord,
In view of above, list the matter again on. Today's 26, isn't it?
at today 26, my lord,
5th of June?
my lord.
Yes.
I am obliged.
May it please your lordship, my lord, this petition has been brought at my instance. Since 2024, my lord, I have been, penalty was imposed, one stoppage of one annual increment. My lord, without furnishing me any inquiry report and others. So I was prejudiced by not furnishing my representation and others. The whole
Where is the
issue-
impugn order?
The impugn order is at page, it starts at page 69.
This is the second one.
Not second, I was suspended, I approached this court because the whole case is that, my lord, as a lady, mother, I wanted a childcare leave. I requested for a childcare leave. When I entered the inspector's office, he rebuked me and threw me out by molesting me and out me of my chamber, his chamber. I lost an FIR. And then, my lord, I was suspended because on that basis, and ultimately during my leave period, my lord, I was given this punishment. Whole issue is this, the charge, a statement of allegation is at page, your lordship will find. Earlier order is as rigorous suspension. And the statement of allegation, your lordship will find. At page 58.
No, this is, see, Mr. Chaudhary, this is the second time you're coming.
My lord, because earlier one, it was because of suspension,
1141.
my lord. That order
And,
is
and
that
this is, and the present one is regarding?
my penalty,
Yes, present case is regarding
penalty.
penalty.
Imposition of stoppage of one increment.
Okay.
And
Where is the
earlier
penalty?
order is at
Where is the
page-
order?
Well, that is at page 69. Relevant is at page 70. First paragraph.
Okay, so now have they filed counter affidavit?
No, my lord, nothing. Page 70, your lordship will find.
You're
based
still
on the-
working?
My lord, my instruction goes, I think I have already retired. my lord.
When did you retire?
That is not, my lord, because I have not in contact with her, because nothing has been done from the other
What was
side.
your age
Age during
on
that
filing
time,
the writ
20
petition?
My lord, during that time, my age was,
56.
well, 56.
And the writ petition is of the year 24.
24.
Age of retirement is how much? 60 years.
60, is still working, I think.
You're still working.
Still working.
Who's appearing for the department?
I'm appearing.
Yes, what is your submission?
My lord, instruction is required here, and since the it is.
When will you
matter
give
is
the-
Come for order, my lord, it may become in admission column, my lord.
So what? What does it, what difference does it make? Whether it comes for orders or for admission? Net result is you don't have the instruction.
Yes, I have,
If it comes for admission, you will have instruction.
no, my lord.
Then what kind of submission is that?
No, some time is
Mhm.
required, my lord, some time is.
If you
required
want
to
time,
get-
you tell time. You say let it come for admission. If it comes for admission, then what will happen? You'll make the same submission.
Yes,
I have no
yes,
instructions.
yes.
So when will you get the instruction?
2 weeks may be granted, my lord.
All right. We'll fix a date.
Yes.
Give a date after 2 weeks. 13th. All right. List again on 13/6/2025. Mr. U. Sharma,
Yes, you shall.
learned counsel appearing for the
For respondent number 120. Hello, 120, man.
1, 2, and 3 shall obtain instructions by then. All right.
Met with the lordship, as per office note dated 21/5/2025, service report is awaited.
From
Respondent number 2 and 3, lordship.
steps was taken.
Lordship on 9/1,
Oh, 9/1/24. 2 and 3, they are still there or not?
lordship still there, lordship.
2 and 3, who are they? District Commissioner
District Commissioner
and District Elementary Education. Are you sure?
lordship,
Pulak Patgiri and Monojit Kutum.
lordship,
This was filed in 2024.
lordship. Lordship, then I will take instruction, lordship, if they are still there.
Or you'll take fresh steps. What is to be done?
Then fresh to lordship.
See, notice was sent in January.
Lordship.
So I was thinking of getting it tracked by thing, na? But since 3 months has lapsed already, it's not possible.
Rest of lordship.
You do one thing, you are certain whether they are still there or not. If they are still there, then you take fresh steps. Please write down, neither AD card nor unserved notice has returned back from respondent numbers 2 and 3. Learned counsel for the petitioner to ascertain whether respondent number 2 and 3 are still holding their respective position as on date. Full stop. If they are holding their respective position, petitioner shall take fresh steps within a period of 1 week from today. List the matter again after 3 weeks.
Rest lordship.
Now the admission of the respondent 3 and 4 is awaited.
When did you take steps? Awaited means you have not taken steps.
We have taken, there is they have issued the notice also, my lord, by register post. From the registry, notice also issued.
Are you sure?
Yes, my lord.
This is
I have
Item
checked.
51.
Yes, 51. I have checked, my
There's an office note which says that no steps has been received by the section.
prior to that note, my lord. They have issued by return, my lord, whether any return or that is they have mentioned, my lord.
No, but what does it mean?
This is when they are that ID card not yet returned or no response they have received. The section did not receive any.
No. You have not taken any steps.
We have taken it. That
You have not. Please go through the file. There's no note like that. Call the next item.
Your teacher lordship, my learned counsel is on legs. Kindly pass over for time being.
Which council?
M. Dotto. He's arguing court number 70.
Okay, let him come. First over for the time being.
But in this case, we earlier filed power on behalf of the respondent of 4 and 5, the college and the governing body. Now, my lord, I got the Vakalatnama on behalf of the rest of the respondents. So we'll file a common affidavit in opposition for all of them. Respondent number 6 to 10. Now, today I'll be appearing.
Respondent number?
6 to 10. The service would then be completed. 6 to 10. Earlier appeared on behalf of respondent 4 and 5.
You are for 4, 5, then 6 to 10.
Yes.
Then remaining 1, 2, 3.
1, 2 is the state respondent.
I'll be appearing for 1 and 2.
Okay. What is your submission?
The main role is from the college of Surgery.
We'll file a.
Grievances against the college of Surgery.
Mr. B. Prokasta, learned counsel appears. Mr. B. Prokasta, learned counsel appears for the petitioner. And Mr. Your good name?
That's that.
Mr. S. Das, learned standing counsel higher education appears for respondent numbers 1, 2, and 3 and submits 1 and 2 and submits that grievance is mainly against the college authorities. Mr. P.K. Roy, learned senior counsel, submits that he'll be appearing for respondent numbers 6 to 10, apart from respondent numbers 4 to 5.
That's right.
And prays for
2 weeks.
2 weeks' time to file affidavit in opposition. Prayers allowed. List the matter again after 2 weeks.
On a date to be fixed.
On a date to be fixed by the registry.
No, I like your ship.
Okay, give a date, please. List the matter again after 2 weeks. Make it 3 weeks. 16. List the matter again on 16th. No, have you checked up?
Yes, Manji, I have taken.
You have not taken?
Madam, 2 weeks time may be granted.
Okay, as paid for Mr. B. Sinha, learned counsel for the petitioner is given 2 weeks' time to take steps for service of notice upon the respondent numbers 3 and 4.
Oblige,
List again after 3 weeks.
oblige.
That's item 51, okay?
I appear for respondent for AG.
Mr.
D.
D. Bhattacharya, learned
Then
counsel
only
appears for
please
the
then, my lord. 4 appears, my lord. Only
D.
respondent.
Bhattacharya, learned counsel appears for the AG Assam.
I am appearing for respondent 2 and 3.
And Mr.
P. Hazarika,
P. Hazarika appears for
respondent number 2 and 3.
respondent numbers 2 and 3. 2 and 3?
No, bro. Which key? 51.
We are talking about 51.
Oblige.
Then Loka ka problem is.
Yes. My lord, I only for lordship a typographical mistake lordship in the
What
court
is that
title of the
mistake?
petition lordship. Lordship kindly see page 5.
This is 56.
Yes, lordship, 56. 56.
What is the mistake?
Lordship, it should be lordship.
Page number?
Page 5 lordship, para 3 lordship.
Page 5, para 3.
Yes, my lord.
Page 5.
Yes, lordship.
Okay.
Para 3 lordship. Typographical. This is my lord.
Page 5 is the cost title.
Sorry, my lord, internal page, internal page 5, para 3 lordship.
There is only one pagination, no internal, external page.
Lordship, it should be wife of, but it is indicated or written as a DO. That means my lord, daughter of.
You have to pinpoint the page. I don't know which page, from which page you're reading.
In my IA lordship, 1567, that is page.
Oh, IA.
Yes, lordship.
I'm looking at the writ petition.
Sorry, lordship.
IA.
1567.
1567.
Yes, lordship. Oh, that is.
69. Four two two is there, na? Then 15, what is it? IA. No, there. 1567. We'll pass over the time being, something wrong with the files, okay? We'll come back after some time. Oh, you found it? Okay,
Yes.
it is here.
Hello.
Page 5.
Lordship,
Page 5,
para 3 lordship.
para 3.
Yes, lordship.
Please read.
That upon perusal of the certified copy of the order dated so obtained from the register of this court, it was noticed that in the particulars of the petitioner number 1, Rekha Kolita, she was shown as a daughter of Dharani Dhar Kolita in place of wife of lordship. W means wife of Dharani Dhar Kolita. It should be wife of Dharani Dhar Kolita lordship.
In
And
the order dated 21/3.
Lordship.
Where is the order dated?
Lordship,
21/3.
Page 8 lordship. Page 8.
Which part is that daughter?
Lordship, serial number 1 lordship, petitioner. It is written as a lordship DO. It should be WO, wife of. Petitioner number 1 lordship.
Or DO? It
Yes,
says WO.
lordship. And
Only that much?
lordship, name of petitioner number, lordship, another lordship. Lordship, kindly see page again, lordship, para 3, page 5 lordship. The name of the school of the petitioner number 2, Bobita Nath, is shown as Ansoli SS School, Merkusi, instead of Onsoli High School, Onsoli. It should be Onsoli High School, Onsoli. And lordship, in case of lordship petitioner.
Not Merkuchi.
Yes, lordship.
It should be Anchali.
Yes, lordship. Onsoli High School and Onsoli, comma Onsoli. And in case of lordship, in respect of petition number 3, it should be Putoli dash.
Just a
but-
minute, just a minute. Anchali.
Yes, lordship.
First is it should be daughter of, no, it should be wife of,
Wife of.
not daughter of.
Yes, lordship.
Then second is Merkuchi should not be there. Instead, Anchali should be there.
Yes, lordship.
And thirdly,
And a third lordship, lordship, it is a written here Putali. Lordship, it should be Putuli.
Putuli Das.
Yes, lordship.
Putali Das.
Yes, lord.
This is name of respondent number, petition number 3.
Yes, lordship.
Okay. Anything else?
No, lordship.
These 3 mistakes. Any objection?
No objection, madam.
Heard, Mr.
Yes, Ali.
S. Ali,
Lordship.
learned counsel for the petitioner, who submits that by filing this application, the petitioner seeks the correction of certain clerical mistakes appearing in the order dated 21/3/2025 in respect of the order dated 21/3/2025. Full stop. The learned counsel submits that in the said order, Srimati Rekha Kalita has been shown as daughter of Dharani Dhara Kalita. Full stop. In fact, it should be wife of Dharani Dhara Kalita. Stop. Secondly, the name of the school has been wrongly shown as Anchalik HS School, Merkuchi.
In respect of petitioner number 2, lordship.
In respect of petition number 2. So stop. He submits that instead of Merkuchi, it should be Anchali.
Anchali, HS School, Anchali.
Anchali, Anchalik or Anchali?
Anchali,
It should be
ANCHALI.
Anchali
HS School,
HS School, comma, Anchali.
lordship.
Stop. Hardly, the learned counsel submits that name of petition number 3 has been wrongly shown as Putali Das.
Yes, lordship.
Stop. The correct name is Putuli Das.
Yes, lordship.
Putulidas. Putuli Das. Mr.
P. Hazarika on behalf of S.I. Radha.
P. Hazarika.
Yes.
Learned counsel appearing on behalf of
S.I. Radha.
S.I.
S.R. Radha.
S.R. Rabha. Counsel for the
Respondent number 2 and 3.
respondent number 2 and 3 submits that he has no objection if the correction to the typographical mistake is made. Full stop. In view of above. The correction as sought for by the applicant is hereby allowed. Full stop. In other words, Rekha Kalita will be shown as wife of Dharanidhar the Kalita. And the school in which the respondent number 2 is working will be read as Anchali HS School, Anchali.
Plus.
And the name of petition number 3 will be read as Putuli Das. To stop, IS stands disposed of.
Plus.
As allowed. Very file is on that. Don't you know, check to this all problem. Yes.
Yes, Lordship. This is the same to Lordship. Lordship, kindly see page 8, Lordship. Order dated 21/3 to 25.
Page
Page 8, Lordship. Page 8, para 3, Lordship. Milady, in respect of petition number 3, Lordship, Sanjita Narzari, she was shown as assistant teacher instead of subject teacher. Lordship, it should be subject teacher in place of assistant teacher. And similarly, Lordship, in respect of petition number 6, Lordship, the name of school, Lordship, should be Pub Kharija Bijini High School, Lordship. Instead of Pub Kharija Bijini, Bijni, it should be Bijni.
Any more?
Lordship.
These two only.
Lordship.
Heard Mr.
Yes, sir.
S. Ali, learned counsel for the applicant, who submits that by filing this application, the applicant seeks the correction of the typographical mistake which has occurred in the order dated
21/3/25.
21/3/2025.
Yes, Lordship.
Stop referring to paragraph 3 of the application. The learned counsel submits that the particulars of petitioner number 3
Yes, Lordship.
has been shown as assistant teacher, which is not correct. Stop. In fact, he should be,
Subject teacher.
she should be
Subject.
a subject teacher. So, in fact, it should be subject teacher instead. To stop, he further submits that the name of school of the petition number 6 has been wrongly shown as Pope Kharija Bijini High School.
Yes, Lordship.
To stop, in fact, it should have been written as Pope Khariji Bijini High School.
Yes,
Page
Lordship.
8, I
Yes.
Mr. P. Hazarika, appearing on behalf of S.R. Rabha, learned counsel for respondent numbers
2 and 3.
2 and 3, submits that he has no objection if the application is allowed. Stop. Upon perusal of the application and upon hearing the parties, the correction as sought for by the applicant is hereby allowed. Stop. In other words, the particulars of petition number 3 will now read as subject teacher instead of assistant teacher. Stop. Likewise, the name of the school of petition number 6 stands corrected as Poop Khariji Bijini High School
Yes, Lordship.
instead of instead of full stop. IS stands disposed of as allowed. It file no.
Obliged.
Yes. Yes.
My lord, we have filed a main petition in the month of August 2024,
Read petition.
main read petition, and we are praying for an order IA number 1640.
Yes, IS there. What is this IA for?
I for my lord, initially in the year 2017, Actually, first, my lord, I joined in the year 2010 in NIT Silchar, my lord, as associate professor, my lord. For the last 15 years, my lord, I am in the same post, while my juniors, my students, they have become my boss. Now, my lord, we made this application in August. My lord, after that, it is from this court to that court, and I'm having to come from Kolkata, my lord. My client is bleeding expenses.
What is your good name?
My client's
Your name?
Nripendra Krishna Roy, my lord.
N.K. Roy.
Yes.
Kindly see the last order. Kindly see the last order, 16.5.
You are Mr. N.K. Roy.
Yes, my lord.
Okay. Yes.
We have complied with the order, my lord. I have submitted Vakalatnama,
Ah.
and I have already informed. And this
Who was the
Vakalatnama is
previous
the final.
counsel? Who was the previous counsel?
Previous counsel was, my lord, I was from the beginning. Kindly see all the orders. From the beginning, I am doing the case. And for the sake of assistance, we appointed one advocate. And my lord, we have requested him to give the NOC, my lord. That matter is, we'll settle up the matter, my lord. I am applying for a stay of the order because my client has been deprived since the year 2016, my lord. And my lord, they have already announced in the month of March another bout of recruitment, taking advantage of the quagmire in the courts, my lord. They are going to announce any day. Unless it is stayed, my lord, this matter, my client will suffer immense prejudice and harassment.
Stay of which order?
Stay of this notification.
Which
recruitment order.
notification?
This is intuned in the Annex A1, my lord. They have already taken applications. They are going ahead with the recruitment and everything.
Page number. Page number.
Page number, my lord.
Show me the notification first
It
before
is Annex A1, my lord.
you make up before you make all the
It is
submissions.
page number 81, my lord.
81. Yes, what is this?
They have announced another process of recruitment, while my case is pending before your lordship's court. My lord, we have already, in the main petition, we have already prayed for a stay. Now, since a new matter has arrived, we have again filed this, we have had to file this IA, my lord.
Applications are invited for teaching and research and so and so.
For all the posts, my lord, including my demand is, I have not been promoted to the post of professor, from associate professor to professor. It was actually, this was committed in the year 2017, my lord. After that, my client appeared before the NCBC, National Commission for Backward Classes and all, and he, my lord, he could not maintain because it was in Delhi. Now, my lord, he belatedly approached before this court, and he has paid for all his dues from the year 1917, my lord. Now, again, my lord, if other candidates are promoted, he will be again junior to his students, my lord.
This is an advertisement for inviting application for appointment to the post of professor, associate professor, and assistant professor, grade 1, grade 2.
My lord, I have only paid for stay on the recruitment of professors and
Professor.
above. Professor and above, my lord.
Professor.
Yeah, my lord.
You are working as what? Associate professor.
Associate professor, and the professor post has been denied to me for the last 15 years.
Okay, this professor post is for which department?
In mathematics.
In the advertisement. But where is it shown as for mathematics?
My lord, in the main petition, we have mentioned.
No, you come to the IA first. You have shown me this page 81.
Beg your pardon, my lord?
Page 81 of the IA. Let us understand this first.
Yeah.
You are against the advertisement for the post of professor.
Yeah.
You say mathematics. So where in the advertisement does it say that this much post is for the professor of mathematics?
Yes, my lord. It is written over here. Name of post, professor, associate professors, and it is for all the departments. National NIT Silchar invites online application from Indian nationals possessing consistently good academic record.
How many posts?
That has not been announced, my lord. Now this.
There are total 82. So backlog is there, then fresh is also there, isn't it?
He can participate. Why he wants to stall the entire procedure?
No.
Because he can participate in the, if he is otherwise eligible for the post, he will be considered.
My lord, then I become junior.
No, we'll see.
I should have been promoted in the year 2017. my lord.
Right, just a minute. Fresh and one is backlog. Fresh post, schedule
Backlog
caste
is also
2, schedule tribe 1, other backward. That means there'll be 2 schedule caste posts for professor, associate professor, and assistant professor. These are all same. 2 posts each.
No, my lord, these posts, backlog posts, my client has not come out of any quota. He has come directly. He belongs to OBC community, that's all. But he has not applied for, as such for this. He is a brilliant professor, my lord, with 15 PhDs in his
We'll
career.
come to your client later on. First of all, let me understand this advertisement. Name of post is this much. Schedule type, there are 2 reserve posts. That means 2 posts for each of this category. Professor, assistant professor, an assistant professor, grade 1 and grade 2. Like that. And for schedule type, there'll be 1 post each.
You know, that is not defined. Professor, associate professor, assistant professors. Unreserved on 8 posts are there.
10, 11, 12, 13, 14.
My client comes from unreserved category. He has joined in the unreserved position, my lord. Now, they have not mentioned how many professors, how many associate professors, how many assistant professors. It has not been mentioned.
How do you understand this advertisement? Total is 16 posts.
16 posts, my lord, but they have not mentioned how many professors.
So, how many professors posts have been reserved for schedule caste?
It is not mentioned, my lord.
Not mentioned. So, how do you read this?
Then, my lord, it is actually the advertisement itself is faulty because it announces that it will be announced in the employment Samachar newspaper. There is no paper called employment Samachar newspaper. It is employment news. Then, my lord, there is no last date for this thing. There is no last date mentioned. You kindly come to, my lord. Last date of submission of online application form will be 10 days after publication in the employment newspaper. Now, when was it published in the employment newspaper? If at all there exists a paper called employment newspaper. Candidates need to send the file filled in, downloaded online application form duly signed. That's right, my lord, you know. My lord, now my prayer is very simple, my lord. Let there be no recruitment in the Department of Mathematics in the post of professor. That's all. Or 1 post may kindly be reserved pending this main application before your lordships.
Yes. What do you say?
Lordship, first of all, the writ petition, the main writ petition in which he has challenged about the notification that was the 24th. Now here in this case, in that particular notification, because he is not participating, otherwise he has to participate because 17, 18 the previous year when this particular advertisement was there, in the year 2017, he did not participate, did not join for the post of professor. If you are not participating yourself, because there is an advertisement, there is no embargo on the part of the petitioner to join the recruitment process with regard to that professor. He is not participating. He has not applied for the post of professor. He is saying that.
My lord, I duly applied. I object to it. I applied. My application was rejected.
That was of 2017, lordship.
We have to come to the main petition.
Let me hear him first. We'll hear you also.
2024-25. It's a very fresh advertisement, lordship. Whether he has applied for that particular post, he has not. Since he has not applied for the post, where from the apprehension comes on the mind of the petitioner, then he will not be considered. And apart from that, he is praying for the stalling the entire process. It goes to show the malafide intention on the part of the petitioner, because there is no embargo, there is no objection on the part of the NIT authorities that he cannot participate in the procedure. So first,
no, what he's saying is that he joined the post in the year 2010.
Yes.
And till date, he has not been promoted.
No, thereafter, when he had applied for the post in the year 2017 or 2018, at that point of time, he was not eligible for the post of professor. So he was not considered. Because now what he is saying that 2017 I had applied for that and I am belong to OBC category, I have been traumatized, something like that, some sort of, all sorts of allegations are there in the entire writ petition. The fact is that when you had applied for that particular post, you are not eligible for that post during the relevant period of time. Now you can apply. What is that bar in applying for the particular?
No, what is the procedure like? Once you join the post of,
No, he has to apply for the post, Lordship. Since the
one has to
entire-
apply.
Exactly,
One has to apply.
exactly, Lordship. He has to apply. He has not applied.
He has all along applied, my lord. This is, they have not replied because they cannot reply to my writ petition. They have, for the last 8 months, they have not been able to reply. And my learned friend may explain whom he is representing. Because the Vakalatnama shows he is representing only for respondent number 12. And who is representing? Whether they have given Vakalatnama.
I am the retainer counsel of the NIT Silchar. I am not supposed to file any Vakalatnama for that. I am the standing counsel of the NIT Silchar.
But it is mentioned only for respondent number 12.
On that, since the person concerned has been arrayed as a party, so I am appearing for that party also. Some directors have been engaged, arrayed as a party to this particular writ petition, Lordship. So I am appearing for those private respondents.
But for them, but it's by name, isn't it?
By name.
You'll have to be engaged.
Exactly, I've been engaged. So that's why I filed the Vakalatnama. What my learned friend is saying, I filed the Vakalatnama for respondent number such and such. I filed the Vakalatnama for the person, who has been arrayed as
a simple submission.
arrayed as a.
This matter is pending, my lord. For the time, I'm not asking the moon. I'm saying in the Department of Mathematics,
Private?
a post of professor maybe reserved for the applicant, my lord.
Yes, yeah, I've understood what your prayer is.
And my learned friend saying he can approach for apply today. If I apply today, I'll be promoted. For the last 15 years, I have been denied this, my right. If I apply today, my right will be extinguished for the last 15 years.
Lordship, in the main writ petition, there is no impugn order. Only thing is that he has annexed one advertisement with regard to the fact that the post of professor, one advertisement has been issued by the NIT Silchar. That is the thing. There is no impugn order, whether he has been rejected, nothing like that.
Mr. Chaudhary,
Yes, Lordship.
you appear for respondent number 12.
In personal capacity, Lordship.
12 only.
No, this 12 for the private respondent. He has been arrayed as a private respondent in this
correct.
particular writ petition. And for the other respondents, Lordship, I am appearing for respondent number 6. I am appearing for respondent number 5. And I am appearing for the these two particular respondents, 4 and 5, 5 and 6.
5 and 6.
5 and 6 as the standing counsel of the NIT Silchar.
And what about the others? 7, 8, 9?
Probably I don't know. The service is complete or probably he has.
Service is complete, my lord. It is
So,
record so
they are
that
not
all is
appearing.
complete.
5 and 6 and 12.
5 and 6 and 12.
11 is the former
Lordship.
ex-director.
Ex-director.
5, 6 and 12.
12. Because some serious allegations have been made against the respondent number 12, Lordship. These are all blunt allegations without any substantial basis.
Okay, you will
For the
submit-
sake of making
submit-
allegations, for the sake of making allegations, these
Submit reply
allegations
to
have
that.
been made.
Why verbal? For the last 8 months, there is no reply. We are moving. I am coming from Kolkata. My client is bleeding.
You will do one thing, we'll issue notice on the IA.
Exactly.
You submit your objection,
Exactly.
whatever you have to do.
Yes.
We have
We'll give a short date.
for the timing, there should be.
No,
time
no.
It will be announced. And
Oh, maybe.
in the Department of Mathematics, appointment of professors would again,
Lordship, any
again,
jun-
in
any
my fundamental
junior,
right.
if any junior is being promoted for the post of professor, he can very well arrate them as a party and he can show that thing that juniors have been promoted and he has
Why,
not been
once-
considered.
but
Here in this
pending
case, there is
your
nothing like
lordship,
that.
How can they announce another bout of recruitment violating the right?
See, anyway, if you succeed in your writ petition ultimately, then appropriate
We have given them notice. for
appropriate
IA.
relief will be given to you. Notice was sent, issued way back on 31st of August 2024. We'll issue notice at this stage. We'll let them file an objection or whatever they want to do. We'll consider this on a given date.
Milord, since they have not replied to the primary principal petition, Milord, now how can we expect that they will reply to the IA?
If they don't, then we'll consider your application.
Milord,
So as simple as that.
Milord, very simply, next week,
Uh,
Milord.
Next week,
Next,
short date, you cannot do that, Lordship.
next week will be too short a date, I
Yes.
think.
At least
Uh,
time is required.
Only 1 week's time, my lord.
One
They've got 8 months time. My lord, kindly-
17, 18.
for the timing,
He's expressing
your
his
lordship
grievance
has
for
immense
the year
power.
2017,
Give a stay.
18.
For the timing, my
This-
lord, let it be stayed for, say, 3 weeks.
Writ petition is barred by limitation,
3
Lordship.
weeks, my lord.
Whatever grievance he has expressed, this is of 2016, 17. And he has come to this, before this honorable court, in the year 2024.
The
After
main,
6, 7
that
years.
will, you make
Agitating the issue.
in the main petition, main argument, my lord, for the timing, let this recruitment process be stayed only for the post of professor in mathematics.
did you file your power, by the way?
Power, yeah, I filed, my lord.
Where is
But
that?
name has not been shown in the cause list.
Where is your
I
power?
filed power, my lord.
Where is
I
that?
can show you the copy.
Name
No,
has
it-
not been reflected.
Power has to be here, not there.
It is not reflected,
It
it's
is not
not my fault, my lord. This is-
He was appearing in this case without any authority, Lordship. The
Any-
last occasion when it was
and-
pointed out,
Any other file?
Been appearing. Kindly,
when it was pointed
This is
out,
the
then he
orders,
said,
my lord.
I'll be filing within a week,
kindly peruse all the orders, my lord, my name appearing for the 5 or 6
without
times.
authority.
No, but where is your Vakalatnama?
Without authority, he was appearing.
File, my lord.
Just a minute.
Without authority.
Is it a checkup? Any Vakalatnama is there?
Without authority. The filing slip is also there, whether he is having that filing slip. Filing the-
I've given it.
This is not the slip.
This one. This is a copy of
I
Vakalatnama.
filed Vakalatnama signed by the,
Some newly engaged counsel is there, Lordship, W. Rahman. He has recently engaged. And that name has been reflected. W.
my
Rahman
lord,
is there.
in the-
He's with you?
there was 6 to 7 advocates who are accusing themselves. First it was Devajit Senapati who refused, then it was Kataki.
Anyway, forget about them. We are
All the
concerned about you now,
Now, my lord, I am advocate, my lord, from the beginning, kindly peruse the orders from the beginning,
not the orders. I want to see the power, your
Exactly.
Vakalatnama, that's all.
even second time.
And
In the
This-
initial stage,
Not a Xerox copy. I want to see the original one.
original power, it should be in the file, my lord.
Power is
He has
once,
to ensure that thing.
Yeah, but
Because there's a specific.
once the
directive
Vakalatnama
within
is
week.
signed by your client, it has to
Exactly,
be
within
filed.
week. His personal appearance is otherwise required, Lordship. Whether he is appearing with the consent of the petitioner, that I don't know.
Petitioner has come, my lord, may I call him? Because they are kindly hear it from the petitioner.
No, I
In the
don't.
initial stage, he filed.
If we are going to hear the petitioner, why should we hear you then?
Petitioner, yeah,
We don't hear two persons, both the petitioner and the counsel. There's no such thing,
excuse me, let the petitioner argue his case.
which says.
I have been appearing for 6 or 7 times.
Learned advocate
that
has
has been
entered appearance
reflected
in
in
the
the orders.
petitioner. But where is the Vakalatnama?
There is not a single Vakalatnama. I've served the, I've checked the file. Not a single Vakalatnama. Not in favor of mine, not in favor of my learned friend.
So how are you appearing then?
No. So then in that case, nobody can appear.
Then we'll
Not
not,
even
not
learned friend.
record anything then. Your Vakalatnama is not
Okay.
here.
Milord, it should be in the file. Let me find out what has
It is
happened.
not in the file. That's why I'm asking you.
No, I'll check out in the office, Milord. Kindly give a short date.
This is the previous council, is it? S. Roy, M.H. Laskar, M. Hussain. Their Vakalatnama is here. These are the previous councils.
Yes, Milord. I have been appearing from the very beginning. Actually, these advocates have been recruited by me for assisting me because this is a new court for me.
You are Mr. N.K. Roy.
Yes, Milord.
Okay. Yes, it is here. The same thing, but this is a bit different, isn't it? Apart from you, who else is there? D. Senapati is also there.
Waidu Roman is most.
No. You are Mr. Nipendra Kumar Roy.
Yes, Milord.
Okay, there are two other names here. D. Senapati and Miss S. Kataki.
That is what I was going to tell. Senapati was initially appointed. Subsequently, he refused to continue with this case. Then we appointed Bhunia, Mrs. Bhunia. Then she too absolved herself from this case. Then we inducted Shukumal Roy. What Shukumal Roy has done, he has, without our authority, prayed for an adjournment of the case when he very much knew that I am coming from Kolkata with flight. Then, Milord, we have requested him for NOC. We'll settle up the matter with him, Milord. Now, Waidu Roman has been appointed as
You are
an
Mr. N.K. Roy, correct?
Yes, Milord.
Okay, we are concerned with that only. Forget about the others.
Milord.
Mr. N.K. Roy, learned counsel, appears for the applicant oblique petitioner and submits that by filing this application, the applicant seeks. You've taken back the IA. Stay of the notification dated stay of the advertisement dated 10/3/2025 bracket annexure 1. Insofar as the post of professor mathematics is concerned. Full stop. The learned counsel submits that the petitioner has been appointed as an associate professor in the NIT Silchar in the year 2010. But till date, he has not been promoted. And instead, the respondent authorities have sought to fill up the post of professor by appointing others who are much junior to him. Full stop. He submits that since there is no counter affidavit filed in the main writ petition, in the meantime, another advertisement has been issued for filling up the post of professor amongst others, professors of mathematics amongst others. He submits that some protection may be granted to the petitioner. Next para, Mr. S.P. Chaudhary, learned counsel, appears for the respondent numbers
5, 6 and 12.
5, 6 and 12 and submits that the petitioner himself has failed to participate in the has failed to apply for the post of professor when the same was being sought to be filled up in the year 2017. Stop having.
Not 17 lordship, he was not having the requisite qualification at the point of time. Subsequently 2025, because in the main writ petition
24.
24, then 25.
In 17, he was having.
So how many times they're trying to fill up in 2024 as well as this year?
25.
Twice.
Yes. 24, the last year it was there. So last year he has put to challenge before this honorable court.
Milord, his application was rejected without any grounds.
Submits that Abakat Thai Chimero. Submits that when the post of professor mathematics was supposed to be filled up in the year 2024, the petitioner failed to apply. And similarly, against the latest advertisement, the petitioner has not even applied for and cannot seek stay of the same. Full stop. Be that as it may, the learned counsel submits that he may be given a short time to file a response to the IA. Considering the submissions, let notice be issued, returnable by short date.
At least 3 weeks, because I have to send it to Silchar. After rating, then they will send it to me.
Milord, they will announce by the time, Milord. Any day this result will be announced. My humble petition is that only one proposed.
No, results mean what? Where have you stated here that they'll be announcing the results shortly? Have you stated that?
You expected, Milord, by the
statement. I'm asking your statement. Statement.
Yeah, I have it.
Your statement.
In the IA.
We don't pass orders like that unless you give some statements, specific statements.
Yeah, I have kindly come to the paragraph.
Paragraph?
Paragraph 9, Milord. That the petitioner has no other remedy at present, and unless the prayer for the interim stay is granted, the petitioner shall suffer immense injury. That is
that is a general statement.
General statement, Milord. Prior to that, I have already signed, Milord, original petition, paragraph number 8, Milord. That in the original writ petition, a prayer for interim stay on further recruitment to the faculty was duly made and actually moved at the time of admission. But the Honorable High Court, having ostensibly reposed trust on the sense of the respondents, NIT Silchar.
All right. In view of above, issue notice returnable by 16th of June. Mr. S.P. Chaudhary, learned counsel, accepts notice on behalf of respondent numbers.
Extra copy news.
Respondent numbers?
5, 6 and 12, lordship.
5, 6 and 12. Anyone appearing else? Anyone else?
What is it?
Milord, is it fixed on 16th June, Milord?
Yes.
Milord, grateful, Milord.
Petitioner, applicant to serve requisite extra copies of the application to Mr. S.P. Chaudhary. within the course of the day?
Today itself.
What about the others? You'll take steps?
Others, Milord,
Other respondents?
other respondents will submit before
No,
immediate,
no,
we'll,
why should I?
we'll send it by post, Milord.
Yes.
Service
Petitioner,
complete.
applicant,
Itself will send it by post.
applicant shall take steps for service of notice upon the remaining respondents by registered post with ADDU within three working days.
Alright.
You please take back this. There's another Vakalatnama in a different format in your name. This one you've taken out is different.
Milord, Milord.
Lordship, item number 39, I'm so sorry, Lordship, it's adjourned for 1 week, Lordship.
39, we have dismissed it.
Lordship, I haven't any instruction from.
Huh?
I have not any instruction so that I can't attend, present in the court. Lordship, kindly.
Then you should have appeared before the court that you need some more time. Why you have not appeared? We have passed the order, madam, sorry. Yes, next item.
Met with the Lordship. Lordship, this review petition was filed by the department Lordship.
By the department.
By the department.
Review of what?
Against the order, your Lordship will find it page number 21, Lordship.
Page number 21.
Lordship. There was a direction in this order, Lordship, to consider the case of the petitioner for compassionate appointment by placing in the district level scrutiny committee.
Just a minute, 21.
Lordship.
Okay. 21. What was the
Direction, Lord.
direction?
I'm sorry, Lordship, today the brief is also not there with me. I'm just briefing while going through the.
Now, this list was out last Friday.
Lordship. And Mr.
You should have been ready.
Mr. N. Happiness appeared and.
Whoever it may be, you should have been ready.
Lordship. Otherwise, Lordship, the matter is very small, Lordship. Whatever, Lordship, this direction was there.
We'll dismiss the review petition then.
Lordship, the Lordship will fix next week, Lordship.
Why? Why next week? Why not today? Why are you seeking review?
Because there was a direction to place the case of the petition before the DLC for consideration.
Is a second copy? You take the second copy.
Because this is a review petition, so there is no copy.
Oh, there's no second copy.
Second copy is not there. Otherwise, I would have a Lordship. And what happened, Lordship? There was a direction to place it before the DLC, Lordship. Lordship will find in the order at page number 21 that annexure C.
Yes, 21 extra C.
Lordship.
Accordingly, the writ petition stands disposed of with the direction to the respondent number 2 to make necessary arrangement for initiating the process of regular appointment
Lordship.
and selection for the post of Chowkidar and in the grade 4 post in Putoli ME Madrasa School.
Lordship.
So what is wrong in this judgment?
Lordship, in the meantime, Lordship, that process has already been initiated, and the regular appointment has been made.
In whose favor?
In favor of the private respondent, Lordship. But to that particular fact was not brought to the notice of this honorable court while passing the order.
Okay.
And even the name of the petitioner was considered twice in the DLC, Lordship. Lordship will find the DLC report. The first DLC was, your Lordship will find at page number 14, Lordship. 23/4/2013. His case was placed before the district level scrutiny committee. This fact was also not brought to the notice of this honorable court while passing the order, Lordship. Page number, annexure A, page number 11 is the first DLC minute, Lordship. And
Page number 8.
page number A1, A is the annexure A, page number 11 is the
Yes.
first minutes of the DLC. dated 23/4/2013.
Yes,
The Lordship will find the name of the petitioner at serial number 25, page number 14.
yes,
And his case was rejected on the ground of Lordship for want of vacancy, the Lordship will find.
yes.
And again, Lordship, Lordship will find at page number 19, Lordship, Annexure B. The second DLC was constituted on 29/12/2015.
Page number
Page number 19.
19.
Page number 19, your Lordship, that serial number 24, your Lordship will find the name of the petitioner.
This is DLC dated?
Dated 29/12/2015.
No, no. Second one.
Second one.
Second one is
Second one
different.
is 9/1/2015, Lordship, I'm sorry.
Ah, that's what, 9-1.
9/1. 9/1/2015, Lordship. Your Lordship will find at page number
Petitioner is at,
Your Lordship will find the name of the respondent, page number 19 and serial number 24.
DLC dated 9-1,
DLC dated 9/1/2015,
2015.
Lordship. And Lordship, here
What is the name of the petitioner?
Lordship, name of the petitioner is Prafulla Kumar Nath.
Nath,
Your
okay.
Lordship will find it, serial number 24.
Now, what is the remarks here?
It was rejected for late submission, Lordship,
How can it be?
because twice, Lordship.
How can it be?
Twice the.
First time you
because-
say that there is no vacancy. Second time you consider say late submission.
And Lordship, there was a direction to initiate that.
No, no, you are blowing hot and cold.
Appointment. Lordship may fix after next week, Lordship, any date, Lordship, I will.
Sometimes you're saying no vacancy, sometimes you're saying late submission.
Lordship.
Stick to one,
Lordship.
either of those.
Lordship, fix next week,
Huh?
Lordship. And today I'm little constrained that the brief is not with me, Lordship, so
But notice has been gone, has been sent to the petitioner.
Lordship perhaps.
I mean to the respondent, read petitioner.
Perhaps, Lordship.
Perhaps.
Because the matter has been now fixed on admission, Lordship.
We'll see, let us see. As per service is complete as per the Lavazima court's order. It's been so many orders are there, I don't know why. Have you read the order?
Lordship.
Order being challenged. Have you read the order?
No, Lordship, I couldn't go through the entire.
But you know about the DLC.
Lordship.
How do you know about the
I just
DLC?
went through the record once, Lordship. I just
Okay.
went through the record. Lordship, can you fix the matter next week, next Monday, Lordship? I will come.
No, no, no. See, one thing is that his father died
Lordship, in 1999, Lordship.
1999.
And he applied for the compassionate appointment in 2010, Lordship.
No, we're not regarding, this is not regarding compassionate appointment.
Exactly.
Okay. His father died in 1999.
1999,
And in the state vacancy,
Lordship.
he has
He
been
was
appointed
temp-
on temporary basis. Chowkidar.
Was appointed by the school managing committee.
Okay, whatever it may be. He is working on temporary basis
Lordship,
for the last 17 years.
Lordship,
So he also says that he does not insist
Lordship,
that he may be considered for compassionate appointment.
Lordship.
But court said that
While
you fill up the post and you consider his past experience.
through regular process,
Ah,
Lordship.
and now you say that the post is already filled up.
That regular process for regular appointment has been initiated.
Already initiated.
Initiated, Lordship, your Lordship will find
Page.
Annexure D, Lordship. Annexure D,
December.
Lordship. Therefore, Lordship, I couldn't go through the entire fact, Lordship. Lordship will fix on Friday, Lordship.
So December 2015.
Lordship. That regular process was initiated, Lordship.
Who has been selected?
Lordship, that.
Who is selected?
Private respondent is there, Lordship. Lordship, I will bring the entire fact, Lordship. Lordship may fix on Friday.
All
This
right,
Friday.
all right. We should not keep this matters pending like that.
Lordship, fix
If
Friday.
there's nothing in this, we'll dispose it off.
Lordship,
If there's something, we'll see.
Lordship.
Heard, Mr.
PN, sir.
P.N. Sharma, learned counsel for the petitioner who submits that cancel the order again. Mr. P.N. Sharma, learned counsel for the petitioner's prays for some accommodation. No, cancel that again. Mr. P.N. Sharma, learned counsel appearing for the review petitioner, submits that the matter may be listed again on Friday,
Lordship.
on 30/5/2025,
Lordship.
since he does not have the brief with him today.
Lordship.
Next para. By filing this review petition, order dated 5/6/2017, passed in WPC number 1547 of 2014, he sought to be reviewed. To stop this, court had directed the respondent authorities to fill up the post of Chowkidar in Fultoli ME Madrasa School, in which post the respondent / writ petitioner has been working on temporary basis with effect from 24/9/2001. After the death of his father, who died in harness on 12/10/1999, while functioning as the Chowkidar. Stop. The learned counsel submits that prior to passing of the order dated 5/6/2017, a process for filling up the post of Chokidar in the said madrasa had already been done. And do you know the name of the petitioner's father?
Petitioner's father lordship. At the moment, the record is not there with me, so I'm sorry, guys.
WPC is here.
WC is there. The second
Just
line
check
is
up
there.
the name of the father.
Yes.
I'm disposing it now only. Name of the father. Is it Moneshwar Nath?
Late Maheshwar Nath.
Moneshwar Nath.
Maheshwar, it is written
Maheshwar.
Maheshwar Nath.
Name of the school?
Name of the school is
Fultoli.
Fultoli ME Madrasa School. ME Madrasa, Hojai.
What did I say last? And white order dated 29/12/2015. Bracket annexure D. One Imdadul Rahman, son of late Lamal Uddin, has been appointed as grade 4 bracket Chokidar against Fultoli ME Madrasa. To stop, the said fact could not be brought to the notice of the court at the relevant time, and therefore review has been sought. To stop, the learned counsel also submits that, in fact, the case of the petitioner had received consideration by the DLC, which met on 23/4/2013 and 9/1/2015. To stop, be that as it may, the writ petitioner had not pressed for his consideration on compassionate basis, which can be seen from the order dated 5/6/2017, sought to be reviewed. To stop, since the post concerned has already been filled up, as indicated herein above, the direction of this court for initiating process for regular appointment of the appointment and selection for the post of Chokidar of the said school has to be recalled. Stop. It is accordingly ordered. Next para. However, it is also observed that if there are any other vacancies to which the respondent oblique writ petitioner can be considered, comma, the respondent authorities would be at liberty. No, the authorities respond authorities would be at liberty to consider the petitioner, the writ petitioner for being appointed to any grade 4 post, considering the experience already rendered by him after the death of his father. No, rendered by him after that his father cut Lemeroka. Rendered by him in the grade 4 post since 24/9/2001 till the post was filled up on regular basis. Next para. It may also be stated herein that notice upon the respondent oblique writ petitioner has been deemed to be complete as per the Lavazima Court's order dated 1/2/2023, wherein on tracking the postal consignment, comma, it was shown that the notice was delivered to him on 22/11/2022. Next para. The review petition according stands disposed of as allowed.
Much obliged.
Oh.
Please, your lordship. Lordship, with all sincere apology, my lord, that item number 36 of today's list, my lord. This is an order matter, my lord. I appear for the petitioner, but I was not present, my lord. It was dismissed for default, my lord. In fact, the matter has become infructuous. But I have
So what's the worry? Same thing.
dismissed for default, my lord. It looks some.
Huh?
If lordship may be kind enough to, my lord, to record my presence, my lord, and dismiss the writ petition as being infructuous, my lord, with all sincere apologies. Otherwise, I am told, my lord, that lordship has dismissed the matter, my lord, for.
You have dismissed it. So order is already passed. What to do?
I take it.
Let it remain like that. It's okay.
My lord, I'm so obliged. I'm so. obliged.
Yes. Next. IA. What is the IA?
I am, my lordship, only for interim payer, filed by the petitioner, the IA, order dated 2/05/2019, page number 115 in our reply matters. Page number 115.
What are you saying?
The applicant writ petitioners are directed to submit their appointment orders on the
No.
basis of which
From where are you reading? What are you reading?
115 page.
Of
I filed the reply
IA.
IA. 115.
115.
115. Order dated 20/05/2019.
There's no 115 in IA.
115. May I read?
What are you saying?
Lordship, may I read?
Don't read. You tell me where you are reading first. You're reading from the IA or from the writ petition?
Yes.
What? Yes. You're reading from the IA or from the writ petition?
Page number 115 in the order.
115 of?
The order.
115 of the order? What do you mean?
The order is number 115, my lordship.
We have also not been served a copy, my lord.
No, sir.
115 is from the rate petition, not from the IA.
The petition person I guess.
You understand? Yes, what do you want to show?
We have, as per the direction of this honorable court, we have enacted all orders. Appointment letters of the petitioners annexed.
So,
The writ petitioners are directed to submit their appointment orders on the basis of which they are claiming to have served as assistant teacher in LP ME Madrasa school in the district of Nagaon. Such appointment orders shall be placed before the court by the applicant writ petitioners by way of affidavit.
yes, when did you file the affidavit?
And we have already filed.
Hmm?
We have already filed.
When did you file? There must be a date.
Date 6/8/2024.
Have you given a copy?
We have not received that, but my lord, we have filed an affidavit, my lord, on February 2025, which is basically the, my lord, our affidavit in opposition.
Don't branch out to your affidavit. I'm asking you about his affidavit. Have you received it? Yes or no? As per the court record, affidavit is filed on 7/8/2024.
My lord, we don't have a copy of it.
To bring on record to bring on record certain relevant records as directed by the court, white order dated 25/2019.
19.
You serve him a copy?
Yes, so I'll be needing a copy of it.
Learned counsel for the petitioner shall serve a copy of the affidavit filed on 7/8/2024 to Mr. A. Fukan, Learned standing counsel appearing for
Elementary
Education Department within 2 days. List the matter again after 2 weeks.
Yes.
What is this IA for?
I have for it till the final disposal of the writ petition.
Any order passed?
No, I
No,
know.
no.
In that IA, my lord, in that IA already we have given our, my lord, opposition, my lord, saying that we already, my lord, if your lordship takes up the IA, at page 18, my lord, this is my affidavit in opposition. There we have categorically stated that there was a committee which was formed, and after the committee has scrutinized the people who have approached before the committee, my lord, at paragraph 3, page 21 of the affidavit in opposition filed by us, lordship, there applicants admittedly, my lord, falls under illegal irregular category, and my lord, accordingly they have appeared before the screening committee for verification of documents. It is very pertinent to mention herein that the applicant number 1, 2, 3, 4, 5, 6, and 7 and 8, 10 and 11 have neither received salary nor have they acquired any training.
Okay.
Hence, they could not.
Mr. Pukan, anyway.
Yes, your lord.
There's no interim order pass, isn't it?
No.
It'll remain as it is.
As it is.
After 2 weeks, list again after 2 weeks.
Lordship, here in this matter, the department has already passed a speaking order on 25/10/2024, Lordship.
Speaking order?
Yes, Lordship, rejecting the claim of the petitioner
What is the claim?
for pro rata pension, Lordship.
Let us see the order first. I mean, the prayer first.
Yeah, please, your Lordship.
To release the pro rata pension
Yes.
benefit grant. Writ petition was filed in 22.
If
Have you received a copy of this?
Lordship, I am appearing on behalf of M. Chandra. I am praying for 4 weeks time to file affidavit in reply.
There's no requirement. You withdraw this writ petition and file a fresh one.
Yes, sir.
He has to challenge that order.
Subsequent development has taken place. Any amount of affidavit opposition will not do unless you challenge this. Next, please write, by filing this writ petition, the petitioner has prayed for a direction to the respondents to release the pro rata pension earlier granted to him or her, him,
Him.
by the Under Secretary, Government of Assam, Education bracket S Department by letter number ASE 308/2007/110 dated 1/10/2009. Page 17, if you, in case you want to check up. Page 17. Stop Mr. D. Upamanya, Learned Counsel, by producing order dated 25/10/2024, submits that a speaking order has been passed by the Secretary to the Government of Assam Higher Education Department to the effect that pro rata pension cannot be given to the petitioner by the department on the grounds mentioned in the said order. He therefore submits that since there is a subsequent development in the matter, unless the petitioner
Part of the record for you.
challenges the order so passed, no relief can be granted to the petitioner. The Learned Counsel for the petitioner agrees to the submission. In view of above, writ petition stands disposed of as not pressed. However, liberty is granted to the petitioner to file a fresh writ petition to challenge the order dated 25/10/2024, if so advised. The order dated 25/10/2024 is being retained in the record and marks as X for identification.
Highly appraised.
Make leisure losses.
Yes.
Case leads to regulation of the gate for employee, my lord. But similar case is pending. Lordship, kindly take the matter along with 667/2023. It is going to be here, my lord, for admission in the month of first week of June.
How is it similar?
Similar.
Same petitioner.
Same petition.
Same petitioner.
No, my lord, not same petitioners. Matter is similar. Same list, same appointment. Everything is same.
My lord, Mr. B. Chaudhary is on his way, my lord. He is appearing for this matter, my lord.
Right now, I have seen he is
on his way. He's coming.
When is it going to be listed, that case, the other case?
in the month of June.
June.
But that is not fixed, my lord.
Date is not fixed.
Fixed.
You want a date to be fixed?
Yes, my lord.
When do you want it?
10th June, then. It's a hearing day because 3 more cases are there.
Okay. Ms. K. Devi, Learned Counsel for the petitioner, submits that there is another similar matter pending before this court. That is WPC number 667/2023.
Chandra Deka and 39 others.
And therefore, the instant writ petition may be tagged along with that case. And the matters be listed on 10th of June 2025.
67/2000. Naya Kasat.
10 June, he says. Mr. Chaudhary?
Yes.
Mr. B. Chaudhary, Learned Counsel, appearing for the respondents, has no objection to the prayer. In view of above, list the matter along with WPC number 667/2023 on 10 June 2025.
Oblige.
May I have legal officer? Also, in this writ petition, the petitioner had made 3 prayers. The prayer number A and C has already been granted to him. With regard to petitioner, the prayer number B, that is for inclusion of his name in the sub-divisional wise gradation list.
Because if the regular selection is set, then I will be appointed as a regular headmaster. Now, since the petitioner is going to retire in August, this year, Lordship may kindly consider this second prayer. If the selection is held in the meanwhile, within the month, then I can be posted as a regular headmaster. Otherwise, Lordship, my prayer number A and C has been granted.
No, what about prayer B then? What do you want?
To include my name in the subdivision wise gradation list, because I am the senior most, going to retire in August. Headmaster selection
Otherwise, there was a process, and Lordship, my instruction is that this school has already been amalgamated with some other school. So, railway? Bongaigaon Railway High School, Lordship. So,
Anyway, Lordship, my prayer number A and C has
no
been.
longer the headmaster of this school, respondent
Who?
number 5, because this school is amalgamated with the railway.
He is no longer at the present.
What are the schools which have been amalgamated?
Then this respondent number 5 school, Rajendra Vidyapith ME school.
Yes, and which other school?
It is amalgamated with the railway, Bongaigaon Railway.
And now the name is, what is the name now?
Bongaigaon Railway High School, Lordship.
Bongaigaon Railway High School.
Yeah.
Is it like that?
I don't have the instruction.
So let me have the concrete instruction, Lordship.
What you are
So
saying is
if my
that-
learned friend is also not having that instruction, let him have the
Anyway,
instruction.
Lordship, my petitioner got relief. The prayer number A and C has already been granted to him. Only with regard to prayer number 2. If my name is included in the subdivision.
Lordship, this school has been amalgamated with Netaji Hindi Vidyapith MB School from July 2022.
Yes.
Netaji?
Netaji Hindi Vidyapith MB School.
ME school,
MV.
MV,
School.
and now known as,
This is the school now known as.
sir, not railway school. You were saying railway school.
I said it was earlier railway school, that was also.
No.
Present school is Netaji Hindi Vidyapith MB school.
Earlier it was Rajendra Vidyapith.
Rajendra Vidyapith, then another railway school, all school has merged with this Netaji Hindi Vidyapith MB school.
So Rajendra Vidyapith has merged with railway school.
No. Also, even without mentioning the name of the school, Lordship may kindly
It is,
dispose of this matter by
Rajendra
saying that the
Vidyapith
petitioner
ME
has got the
school.
relief of prayer number 1 and 3, and Lordship will consider.
No, that we can do, but I just want to know the facts. Which school and which school has been amalgamated?
Vidyapith ME school
Yes, and
amalgamated
with
Netaji Hindi Vidyapith MB school.
and now known as Netaji.
Vidyapith and Netaji Hindi Vidyapith MB school.
Okay. So it is no longer Rajendra Vidyapith.
No longer.
Okay. So prayer A and C is already given. Now prayer B is to include the name of the petitioner in the subdivision wise gradation list of teachers in order of seniority to enable him to participate in the promotional process of regular headmaster being undertaken by the district. So can we say that it should be considered?
That with respect to gradation list, another writ petition is filed challenging his seniority method. This is another case is pending.
What is that case number?
Case number.
WPC? Are you aware about that?
Yes.
Then tell me, why are you just keeping silent about that?
No, because in this repetition also my, yes, sir, my prayer is Lordship, the prayer number 1, 3 has already been entered. My prayer
A and C is already over. What about B? To consider B, that case also has to be taken into consideration. Somebody has challenged your gradation.
No, my name has not been included in the gradation.
Oh, whatever it may be, but that case is pending. You should have also told me that. What is the case number? Case number.
Petition number 3029 of 2020. Manoj Kumar Singh, but he is no longer in the particular.
3029 of
3029 of 2022.
2020. 22. What is the status of the case?
Status Lordship, my learned friend has filed.
Stay
We have filed.
Stay of what?
Stay for not taking the consideration of gradation list in the seniority list of the respondent They are respondent in
Say-
a petition.
He's the writ petitioner.
In this case, he is
In
red
this
person.
case,
In that case, he is.
In that case,
In that case, he is the respondent
in that case stays in favor of whom?
in favor of the writ petition.
Writ petitioner. So we'll say, let his case be considered for gradation, subject to the outcome of this 3029 of 2022.
Also, he is no longer in the present in my school also. He is no longer there.
Maybe, but the writ petition has to be considered also. Because later on, they'll come back with review saying that this writ petition is pending.
Subject to outcome, Lordship.
Heard, Mr.
SK Das.
SK Das, learned counsel for the petitioner, who submits that the petitioner has already who submits that amongst the three prayers made by the petitioners, namely within bracket small a, within bracket small b, and within bracket small c, comma, prayer A and C has already been given to the petitioner. Stop. Now, what remains is with regard to prayer within bracket small b, which is for a direction to include his name in the subdivision-wise gradation list of teachers in order of seniority to enable him to participate in the promotional process of regular headmaster being undertaken by the district level selection committee. Full stop. The learned counsel submits that the petitioner is due to reach the age of superannuation in the month of August, correct? 2025. And therefore, there is some urgency in the matter. Stop. Next para. Mr. P. N. Sharma, learned standing counsel.
For respondent number 1, 2, and 3, Elementary Education Department.
Elementary Education Department, appearing for respondent numbers 1, 2, and 3. And Mr.
SK Ghosh.
S.K. Ghosh,
Respondent number 5.
appearing for respondent number 5, submits that Rajendra Vidyapith ME School and Netaji Hindi Vidyapith MV School has been amalgamated into one school under the name of Netaji Hindi Vidyapith MV School. Stop. They further submit that another writ petition is filed by one Sri. Who is the petitioner?
Manoj Kumar.
Ajay Kumar or Manoj Kumar?
Yes.
Filed against the petitioner, against the instant petitioner, being WPC number 3029 of 2022, which is still pending disposal. Next para, upon considering the submissions so made, the present writ petition is disposed of. By directing the respondent authorities to consider inclusion of the name of the petitioner in the subdivision-wise gradation list of teachers. Which, however, would be subject to the direction to be passed in WPC number 3029 of 2022. With the above observation, when direction writ petition stands disposed of.
Lordship, consider as per laws.
Consider. Consider, what did I say?
Already still here.
Before that, before that, just before that.
Yeah.
In accordance with law. Subject to so and so. Yes. Okay, what the case number I've given you, na? 3029. Within bracket, after that you just write Manoj Kumar Singh versus State of Assam and 5 others. It's party name. You put this in the file.
May it please your Lordship. Lordship, as per my instruction here, Lordship, the petitioners has been accommodated as teachers or tutors. These petitioners have been accommodated in terms of the cabinet memorandum of 2020 lordship. So if my learned friend have any instruction, otherwise I will file affidavit.
My lord, may I draw my lordship's kind attention to the order dated, my lord, 14/2/2025, my lord, passed in this petition, my lord.
Yes.
My lord, pursuant to this order, my lord, they are required to release our salaries. Now, my today's instruction is that, my lord, despite there is an order, my lord, till date we have not been paid. On the last occasion also, my lord, on 12/3, my learned friend took time to obtain the instruction, my lord.
What is this matter regarding payment of salaries?
No, my lord, what has happened, my lord, we have been compelled to sign an undertaking, my lord, that the once those persons who were, my lord, appointed or regularized after the 2005, they are required to be abide by the new pension rules, my lord. So to that, my lord, context, we have raised objection. Now, this honorable court, my lord, we have challenged that part mainly in this petition, my lord. Then this honorable court, while issuing the notice, said that on protest also you can go and join, and we will examine on the later on. So, my lord, thereafter we join, but my lord, the salary part, my lord, we have not been paid, my lord. Now, the issue regarding that whether we are required to sign that undertaking or not, that is under examination before my lord, my lord.
Salaries.
My lord.
Mr. Sharma, anything about salaries?
Lordship, what happened, lordship? They were initially appointed illegally without following due process of law. Hence, they came under the ambit of illegal and illegally appointed teachers' lordship. Therefore, in 2020, a cabinet decision was taken. There were appointments were made across the state in 1989 and 1991 to 2001 lordship. Several appointments were made illegally without following due process of law against non-existent post lordship. Therefore, they came under the purview of illegally and irregularly appointed teachers. Now, in 2020 lordship, the cabinet took a decision that their cases will be considered under certain criteria, lordships. They have to appear before the steering committee. They have to place their records, credentials, and they will be considered in terms of the cabinet memorandum, lordship.
Yes.
Now, subsequently, lordship, they appeared before the screening committee voluntarily, and their cases were considered, and they fulfilled certain criteria. There are a few criteria were there that those who worked till 2007 and received salary up to 2007, and those who undergone that junior basic training. So these petitioners, they come under that category. Therefore, their cases were considered and they were accommodated in terms of the cabinet memorandum of 2020 as teachers. And with the condition that their appointment will be with prospective effect. And they shall not claim any arrear benefits, lordship. After furnishing these undertaking, they join their respective schools with prospective effect. And they are getting their salary from 11/2020. November 2020, they are getting salary, lordship.
Then
and they accepted that they will.
So what is pending now? You're asking for salary of
Arrear.
prior to that
Prior to
November.
My lord, my learned friend instruction is not correct, my lord. My lord, what has
Let
happened?
let me bring on record by way of affidavit,
My
lordship.
instruction is that, my lord, till date we have not paid a single month's salary. What has happened, my lord? If my lord may be pleased to
Since when? Since when?
Since the date of our joining after this order of 30th January 2021, my lord. We are not claiming arrear, my lord. We are now claiming the salary from the date of our joining pursuant. My lord, may kindly turn to page 76, my lord.
Date of joining is?
My lord, the date of joining we have joined in our additional affidavit, my lord, we have brought everything on record, my lord.
Give me the date, that's all.
Yes, my lord. On 26/2/2024, my lord.
Since 26 to 2024.
2024, my lord.
Only that much you're claiming?
Yes.
From
because,
February 24, you're claiming?
Because, my lord, what has happened? Though our appointment order had been issued, my lord, we are not been allowed to join because we did not sign the undertaking, my lord.
Yes.
Now, pursuant to this honorable court's interim direction, my lord, we were required to allow joining. That has been done only on 26/2/2024. Now, therefore, my lord, we are praying that we should be paid at least from 26/2/2024, my lord.
So, Mr. Sharma, you get instructions
Lordship,
and you file your affidavit.
Lordship, I will file affidavit.
You've got so much submissions to make, but unless you file affidavit,
Lordship.
it will not be in the record. Let
Therefore,
it be on the record.
I am waiting for 2 weeks' time to file my affidavit, Lordship.
Mr. P. N. Sharma, learned counsel for the respondent. Respondent what? Elementary education.
Elementary, my lord.
Respondent Elementary Education Department prays for 2 weeks' time to file affidavit in opposition. Stop. Mr. A.R. Bhuya, learned counsel for the petitioner, submits that the petitioners have not been paid their salary since their joining on 26/2/2024. And he prays that a direction may be issued to the respondents to give them their salaries. Mr. P. N. Sharma shall obtain instructions in this regard by the next date.
Lordship.
List the matter again on so and so. After 2 weeks.
Obliged, my lord.
The date is some on 12/6/2024, 25.
May I please? Your Lordship?
Yes.
Lordship, the matter relates to Lordship non-payment of family pension, Lordship. Earlier it was pension, hereafter, Lordship, the petitioner has been substituted, Lordship, as a pensioner, Lordship, family pensioner, Lordship.
Who's the original pensioner?
Original pensioner, my husband, he expired.
Expired thereafter?
Thereafter, I filed one substitution petition, Lordship, and accordingly, Lordship, I have been substituted, and I am claiming for family pension. At the area of
Substituted?
pension, Lordship.
Why substituted?
Husband died, Lordship.
Naturally, once the husband goes, then the wife will get it.
That's it.
It's called substitution.
Plus,
Wife is entitled to, isn't it? Otherwise. How many wives?
no, single life, Lordship. Lordship. Not
Only one
substitution,
wife?
Not substitution, actually.
Huh?
Not substitution, actually. I am normally I am entitled, Lordship. I am the only other wife, Lordship.
You are the only wife?
Lordship.
Okay.
Now
So-
I am representing the case, Lordship, actually.
So the nomination should be there from your husband also, isn't it? That wife is there. Not required for you to run around here to get yourself substituted. Then
Lordship,
why is it listed today?
Lordship, earlier date, Lordship, respondents were prayed for time, Lordship, for furnishing the up-to-date instruction, Lordship.
Order dated 10/4/23. Let's see.
The case, Lordship.
What is 10/4/23? The director pension is further directed to forthwith return pension papers
Lordship.
to send concrete proposal. Copy of some people. Yes, Mr. Sharma,
Lordship,
you appeared last time also on 10/4/23.
23, Lordship.
Yes, in the year 2023. What have you done? When did the husband die?
Lordship, in fact, there was a hearing was scheduled on Lordship on February, but that could not happen. And now another hearing has been scheduled on 30th of this month, Lordship. So Lordship may fix the matter after.
Hearing for what?
Hearing for the claim of the petitioner, Lordship. The petitioner will appear before the DI of school, Sadia. So there is a hearing scheduled on 30th of May.
DI of school.
Lordship?
DI of
DI
school.
of school.
Sadia.
Sadia. Therefore, let the matter be fixed in the first week of June, Lordship. By the time we will have the complete instruction.
Why that hearing is required?
Because of the claim of the petitioner, there must be some dispute. Therefore, the
Not
hearing.
dispute, Lordship, actually. So far, my
Let me have
discussion,
the-
Lordship.
When did the husband die?
Lordship,
After filing a writ petition.
after filing of the writ petition, Lordship.
So in the year 2023, when this order was passed, husband was alive.
Alive, Lordship, alive.
Please write down. Mr. P. N. Sharma, learned counsel for the Elementary Education Department, submits that hearing about the claim for family pension made by the petitioner is scheduled on 30/5/2025
Lordship.
Before the DIO school?
Before the director of elementary education.
Before the director of elementary education?
Department, Lordship.
Government of Assam?
Lordship.
And therefore, the present case may be listed
In the first week of, or the second week of June, Lordship.
in the
will be-
second week of June.
Lordship.
Considering this submission, list the matter. Give a date. 10/6. 10/6.
Lord.
On 10/6.
March.
2025. Full. Why it was timely? M. Datta. He has not come. But if council is not there, then what to do? You can call in the afternoon. Let's see. Let's wait for some time. Yes.
Because this is the third round of litigation. The petitioner has been denied promotion from the post of peon to junior assistant. And my grounds of challenge before your lordship is on 2 counts. The rules concerned prescribe that, my lord, the incumbent should be graduate first. The private respondents are not graduate, I am a graduate, but still they have been promoted, I have been not promoted. And the second limb of my argument will be, my lord, the same rules provides for the promotion criteria, that is seniority cum merit. And one of the private respondents is junior to me. Still, my lord, he has been promoted, depriving my promotion.
Which department?
My lord, finance taxation department.
Finance?
Taxation.
Finance and taxation department. From grade 4 to?
Peon to junior assistant.
From peon to junior assistant. What is the criteria?
My lord,
Graduate?
No. The rules prescribe that 90% of the posts shall be filled up by way of direct recruitment.
10%?
10% should be by a promotion.
By promotion from amongst the grade 4 employees?
Yes.
Who are qualified?
Yes.
Who are graduate?
Yes.
And of course,
And,
subject to other fitness.
The mode of promotion will be as per seniority cum merit.
Seniority cum merit. So how many private respondents are there?
2, my lord.
2. Anyone representing?
Yes, there is.
For the respondent number 4.
4.
Private.
You're not qualified?
I'm qualified, my lord. So far as my qualification is concerned, I am the senior most peer. I was. And I was promoted.
Are you a graduate?
No. Graduation so far, when I joined in this job, at that time it was not there. And
But at the time of considering of your promotion, what was the criteria?
my promotion criteria was the senior most peer. That is 7 years I have completed or no.
Seniority is one thing, but regarding the educational qualification.
Education qualification, I have done my BCom, but I could not appear because of my financial hardship.
You have done BCom?
No, BCom I could not appear, but I have prosecuted my studies. I am so far as the amendment is concerned, it relates to HSLC. I am not HSLC.
No.
I am still living certificate examination path.
Simple question is, you see, as per what Mr. Patowari submits, if it's correct, in order to be promoted to the post of junior assistant from the grade 4 post, 10% of the post is reserved for those persons who have served as grade 4 and who are graduate. And appointment promotion will be done as per seniority cum merit. Seniority, you may be the senior most, but when it comes to the educational qualification, if you don't meet the criteria, how can you get promoted?
My promotion is concerned, and regarding the qualification, that has got no application in my case, because that very notification has not given any retrospective effect of the promotion or the promoted. And the very order, if lordship kindly.
Okay, we'll see about that. You are for which respondent?
I am for the respondent number 4.
4. And who's the other private respondent? 5. You also same case? What does it say? HSLC or +2? Matriculate.
Doctor, there was a review with regard to this, whether this office memorandum will apply or not.
So what is the confusion now? What is the debate now? Which notification will apply? That matriculate seniority and matriculate qualification will be good enough, or that degree or the graduate degree is required? That will have to be seen to. That's all I think. Matters pending means which matter?
Question with regard to the application of the rules or regard to this office memorandum.
Which rules?
1967.
What is the relevant period for such consideration in this case?
My lord, they have been promoted in the year 2018.
2018.
Yes.
So what was the
Initially, my lord, it was.
what was the rule in vogue that time?
Yes.
2018.
In the year 2015, the main rules were amended and this graduation was brought in, my lord. We have managed all the rules here. Now, what they want to contend that since this is a district ministerial service rules, this was, my lord, adopted by the Finance Taxation Department, the main rules. However, the amended rules, the Taxation Department did not adopt, my lord. That was their contention. And in that regard, the litigation was there, my lord. And this honorable court directed the authorities to pass an order. They passed the order saying that graduation is applicable. And if your lordship doesn't take into account the educational qualification also, respondent number 5 is junior to me. That on that count also I am eligible, my lord. I have been denied illegally.
All right, we'll see.
Yes.
We'll come back in the afternoon.
My lord.
All parties are ready for hearing?
Yes, the are complete.
Are you ready? You're ready. So get the relevant papers and relevant books, whatever is necessary. We'll come back at 2. But there's one matter fixed at 2, I think. First, we'll do that. Then thereafter, we'll take up this matter.
Yes.
And try to make your submissions brief. I think the entire controversy is in a small campus.
Yes.
My only.
Mr. Gogoi.
My lord, the coordinate bench has held that, my lord, the OM, my lord, the notification of 1991, that will prevail.
We'll bring the,
yes.
bring the notification, we'll see. Bring that order.
There I may take a stand that, my lord, it is the amended part that will be, finally, my lord, will have to be taken into consideration. But that was modified. I will place the order.
My lord, for the purpose of hearing, if any other date is picked.
You say that earlier. Why?
In this week, any day,
Why not today? You have some problem?
come with the authorities. Some of the authorities are very relevant. So that I can enlighten this.
Okay, when? Please agree on date. Because there are many other matters we should not lose time.
My lord, 29
29.
this week, ma'am. The hearing day.
29.
29, 30.
All right, list the matter on 29th of May 2025 as paid for by the parties. The learned counsels for the parties shall produce the authorities which they wish to rely upon on that date.
Deeply obliging.
Authorities before that, you
Met to the lordship. With due apology, I want to mention item number 29, my lord.
yes.
This has become infructuous, my lord. The case has become infructuous. In view of that, the matter may be closed.
Ms.
Of course,
Encyclia,
we
learned
got to
counsel
continue.
for the petitioner submits that petition has got the relief and that the matter has become infructuous. In view of above, the writ petition stands disposed of as infructuous.
Obligement.
I'm sorry, madam, I was struggle, my. So this case, your lordship is aware of that case, was about within 90 days or beyond 90 days? That is the question, my lord. The suspension, my lord, when has come, my lord.
Yes.
So your lordship, kindly see, I take your lordships to page suspension order, my dear, can you see suspension order, page 22, page 22. Yes, page 22. This is order dated, my lord, 18/6/24. 18/6/24. What? This order is, my lord, 18/6/24. Whereas
Yes.
yes, whereas an intimation has been received from Sri so and so, vigilance and correction, that regarding arrest of so and so, the petitioner, in connection with so and so. Whereas no further communication has been received from any corner till date regarding release of so and so from the custody of after expiry more than 48 hours. In view of the above, the center so and so, the Kachar is deemed to have been placed under suspension with effect from the date of his arrest for 12/6/24. So suspension is with effect from 12/6/24, but order of communication is dated 18/6/24. So that will be counted from 12/6, my lord. And it expires on 12/9/24. 90 days expire on 12/9/24. Your lordship got it. Then your lordship will find that page 23, my lord. Following officer have appointed in inquiry officer they have appointed. Now your lordship will find 19th September, page 24. Issued the show cause. Page 24. 24 is dated 19th September 24. That is very important, my lord. 19th September 24. Top right side. Page 24. Now
This is only show cause.
show cause. The charge, they have issued show cause to submit, my lord.
Charges what? When was charge issued?
Hey, this is the, my lord, this is.
This is the show cause come charge.
Yes, statement of allegation, everything is there.
Okay.
Page 25, yellow 5, statement of allegation. Charge. Your lordship will find page 25. Reply
Where?
of show cause, I have given a reply also. Your lordship will find page 26 onward. The reply is dated 27/9/24.
This is show cause notice
Yes.
along with statement of allegation.
Allegation.
But where is the charge?
This is the charges page 25, by the way. No, sorry, 20. Yes, 25. Statement of allegation against Sri so and so, so and so, so and so.
This is all in one. Two in one.
Page 25.
Statement of allegation plus charge also.
Charge also.
Plus list of witness also.
Yes.
Plus show cause also.
Show cause also. They have included everything there in the same time. Normally it should be separate. Anyway, let us see, my lord, it is given. Now, the reply also I have given, that reply, whatever reply, my lord, then you will find page 30. Oh, sorry, page 31. Imprint order. That is the order dated 13 December 24. So that it is to be reviewed within, my lord, 12/9/24, but they are passing the order on 13 December 24. Your lordship got it, one date. Bottom. Right side.
Okay.
Now, this is our case, my lord. this 31 page, what are dated 13 December 24.
What is the relief you are seeking for
Okay?
now?
Now, you also got that point about difference. My 3 months might have completes on 12/9/24. They have reviewed it on 13 December 24.
What is the relief you are seeking for? Reinstatement.
Reinstate. Because Ajay Chaudhary, my dear Lordship, has saying within 90 days, you fail to do it, my lord, automatically it cannot survive. It must be, it is mandatory, my lord. And it is reiterated by our court also, this one, my dear Lordship, I have given last time also, my lord. Now they have taken a plea, my lord, in their affidavit, your Lordship will find. They have taken that I have submitted beyond the period of 90 days.
What you have submitted? The
They have-
information
they
regarding
have
your.
reviewed it, my lord, within 90 days, their cases, my lord. And they are taking this order, your Lordship will find page, your Lordship will find page 30. Yeah, page 50, 50, my lord. Kindly say 50, my lord. 50 and 51. They have stated that I have not communicated my date of release. And that will be treated from the date of communication about the release, my lord. That's 90 days to be counted. Assuming, my lord, that I accept their plea, even then, my lord, it is not within 90 days, my lord. Page 50, my lord, I have informed them along with the certificate of my release bail order, my lord. 22nd August 24. I have submitted, it is also there.
So this is the controversy.
This is the controversy. And next page, just one page, man. Next 51. 51, the next 10, page 51. Your Lordship got it.
Yes.
Page 51. What they are saying, madam, your Lordship, and the page 51 is a reminder that was given on 21st September 24.
Reminder they have received.
Reminder given with reference to 22nd August. Your Lordship will find.
But the previous one they did not receive, according to them.
Yes.
So you have the records, Mr.
Yes.
Goswami.
Yes, I have the record.
So what about this controversy?
Yes.
22nd August,
Or
No, no,
20.
that is not available in my report.
not record, not available.
Yes.
I have when it is receipt order is there, madam, they have received it, seed is there, the initial is also there.
Seal is not very clear.
That of course, but they have not denied it, my lord. If they said it is not in the record, my lord, the order which is in their favor, it is in record. And which is in my favor, it is not in record. You also to see my,
This is a part of your reply affidavit or a counter affidavit?
it is our counter affidavit. We have filed it. And that was filed also long back, 3/4/25.
No, this is a reply. Reply.
Yes. In the reply, I have given all these 2 copies. Law is also very clear. Interpretation by the court is also very clear, my lord, that I am entitled, I have a right to be reinstated, my lord. Now, if you look to Ajay Chaudhary and Ajit Salman.
No, why did you mention this in your writ petition
Yeah.
regarding communication dated 22/8?
No, Lordship, it was
28 came from the-
later, on reply, they
Yes.
adduced.
When
But
they have,
in the writ petition, they are not on
that
this.
question was not never
Yes.
arose, my.
In the writ petition, it was not reflected.
What is the writ petition regarding
Yes,
then?
writ petition regarding madam 90, within 90 days now, they have not submitted. Your worship kindly say it when my fare is, my abandonments in the writ petition.
Writ petition was submitted in February.
Yes.
You could have enclosed that document 22/8.
No, that document, that question, because they have never raised any question, madam. It is not that, madam, we have got it backdated. That is also not there, madam. They have never, your worship kindly say what I stated in my that, that also I have mentioned specifically, my lord.
No, but tell me, where have you mentioned about 22.8?
No, 22.8 repetition it does not mention.
You may not have annexed it, but
But your lordship, my whole case was that 1312, that was imprisoned, my lord, 1312. My whole case was there 1312, beyond the period of 90 days. That is my question, my lord.
no, 13.12 is there, no doubt, but
Because
why did you not mention about your release?
Question, my lord. My question is, my lord, my whole case was that within 90 days, they have filed it or not, my lord. Review they have filed or not, my lord. So that question, my lord, that is.
I understand your case is about 90 days, but
They know it, but they have.
why didn't you mention about that your release from jail, from the prison?
Non-mentioning does not take away my rights, which was there very subsequent to my lord.
Why I'm asking? Because there's a dispute now.
Now, this.
You say I've given, they say they have not
I
received.
have replied. I have replied, my lord. They have never stated that this is false, this is fake, this is that. This is not the reply, my lord. Whether they are denying that this might have that order might have, which the letter I have received on 22nd, that is fake, that was not submitted. Is it their case?
Your representation of 2511, let us see.
Yes. 2511, your lawsuitable fine. Yeah.
2511,
Yes.
where is that?
21st, 9.
No, 2511.
25.
Annexure 7, I think. You have mentioned as annexure.
In the repetition.
Yes.
Yes. Repetition, no representation. Huh? 30. Repetition. In the repetition. 30, madam. Two representations you will find. One is details given to the page 26 to the district commissioner, my immediate authority. Details reply to the so-called.
Here also.
You also kindly see here also. Let me see, madam.
Here also you have not mentioned about your release.
My lord, after releasing from custody, your loss kind of page 28.
27.9.
Page 28, bottom, last paragraph. After releasing from judicial custody.
When?
That is not my lord. That meaning thereby before that. Before the submission of that reply 27/9/24. In that reply, I am saying that my lord, representation that after release of my after release of the I have dealt with as a patient of so and so. One of the advocate collected my release order, certified copy from the Court of Special Judge Guwahati, and courier it to my house. I am submitting my release order and courier copy along with that here. It is there. In replying to the statement against so that is very much it was informed, my lord. The release order also given to them. They have not denied it. Photography. Photography was in a messed up.
The other day, Mr. Goswami were relying upon some judgment.
Yes. Yes.
That date of knowledge.
Yes.
Date of information is 11.
Yes.
Where is that?
Lordship, first of all, Lordship, I would like to submit.
No,
Lordship,
my concluded, my lord.
Have you concluded?
No. I have not.
Okay, let him conclude then. Yes.
Let me complete now.
Oh, yes.
So my case is, my lord, supposing if he's that after the communication, after knowledge has come from this representation, which was filed on 22nd. This one. The page 26, 27, 28, page 29. It is dated 27/9/24. Your lordship kindly see.
Which one?
27/9/24.
What is that?
Now, my representation,
Hmm.
in the representation I have stated, that is in the writ petition I have submitted. In the stated that I was released earlier and after release, my lord, I was waiting for depression. Thereafter I got the certified copy, then I submitted it, my lord. Then your lordship will find,
27/9.
yeah,
27/9 and 25/11. But you have not divulged the date on which you were released.
but certified copy was given, my lord.
Where?
Yeah, your lordship kindly see, what is my, your lordship kindly see what I have stated in my representation, page 28, bottom. After releasing from judicial custody, I delved into the depression and as a person of custody, so and so. One of the advocate collected my release order from the court associated Guwahati and courier it to my house. Already I am submitted my release order and courier service to in a good sale by application dated 22nd August 24. It is there. So 22nd August is mentioned in my writ petition. Yes. So 22nd August is taken the writ petition itself, man.
What is this? This is a type copy? Or original copy? I mean, Xerox copy?
Which are release order?
No, the reply to the show cause.
Xerox copy.
It is not a type copy, isn't it?
Is? So,
Show cause notice. Annexure 6.
Annexure 6, yes.
This is a type copy.
Yes.
For
Type
the-
copy, but your left side, your lordship will find the docket number is there and initial is also there. Page 26.
(27/9).
Yes, 27/9. But in 27/9, I have stated that on 28 results are submitted. Oh, sorry, 22/8.
You have mentioned about 22/8,
Yes,
but you have not enclosed that, isn't it?
not enclosed, it was mentioned, might have submitted, might. It was not, never disputed, might of all these things, might. But I have stated 22nd August, I have submitted, might of 22nd August. Take a look on it. We have 6 to the 22nd. Four not there. It's already a place for all three problems. Otherwise, we do the one. We have 6 to the 22nd. We have 6. Now you have to kindly reply, my lord. With paragraph, paragraph 6, answer defendant states that it appears from the record that the petitioner has submitted his so-called reply on so and so.
Where you read? From where you read?
Page 35.
35.
Yes, reply from the government.
Counter affidavit.
Yes, counter affidavit.
Page 35.
Page 35, paragraph 8. In response to that, we have filed this, our reply, my lord.
So they acknowledge regarding 21/9
9.
September, not before that.
No, that is what they are saying, my lord. They are saying that 27/9/24. That is the second my reminder. They are taking that is from the reminder, my lord. Date of reminder, second year one. Whereas my writ petition itself, I have stated by the 22nd August, I have submitted.
Okay.
What more require, my lord? The person doing the clerical post, my lord.
Person holding clerical posts, they have good minds.
My lord.
Clerical posts.
No,
they are the we can say they are the
do not have so
backbone.
much of legal knowledge, but even then I think fine, they have mentioned everything, my lord. Whoever has drafted it, my lord, they have. Yes.
So your basic case is that
Data.
you have been suspended, prolonged suspension for more than 3 months.
Yes, more than 3 months.
Although you were released from jail,
Yes.
from custody,
Custody.
which you have informed them.
inform them.
They failed to take any action.
Yes, my.
And but other side, they're saying that we have received only this on 20
Or the second, my second reminder, my lord.
on only the second reminder was received.
Yes, my.
So before the second reminder was received, we have already extended that
Yes.
suspension.
Yes.
And what is the present status now? You are still under suspension?
Yes, still under.
And what about the
I'm
inquiry?
not getting the suspension allowance also 6 months.
Inquiry? What about the inquiry?
That has not been, it is going on, I think, my.
Still going
It's
on?
not started at all.
No, 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 started, Lord.
No, started, I have never been called.
No, from the.
But even they started, my lord, certainly started, my lord, because they have issued the so-called notice, my lord. So started, it's not concluded till today.
What is the nature of allegation?
Nature of
Absence from duty?
He had taken bribe.
Or because of bribe you were arrested?
Yes, 2,000 rupees.
No, but section is under, he was arrested under section 7A of PC Act, Lordship.
But I am not on that at all, my lord.
Ah, that's gratification.
Yes, I am not on the
Gratification, yes.
gratification, my lord. I am on that, my lord, only what law says, my lord. Whether I should be continued under suspension or should I be reinstated, my lord. And I should get 70% of my allowance, my lord. I'm not getting 70%, it is more than 6 months already now. Huh? One reinstated, my lord, it will not require, my lord. But in a basically thing, my lord, law is very specific. If your lordship is convinced that after 90 days, my lord, they have issued, then your lordship may pass on as per Supreme Court's, my lord. It is absolutely up to your lordship, my lord.
Okay.
This is my.
Mr. Goswami.
Lordship, page 50 of the reply, Lordship, reply to award affidavit, Lordship. Filed by the petitioner, Lordship, it was page 50.
Fifty is not your reply.
No, no.
It
Lordship,
is their reply.
Yes, their
Yes.
reply. I am saying that reply to my affidavit, Lordship,
Yes.
by the petitioner, Lordship. This 50, Lordship.
Yes.
50, Lordship, it was addressed to the additional deputy commissioner, Lordship. The suspension order was by the, passed by the deputy district commissioner, Lordship. It is not, it is very clear that no information was given to the proper authority. It means the deputy commissioner, Lordship. He was.
Any difference between district commissioner and deputy commissioner?
No, yeah, same, Lordship, but it is additional deputy commissioner. This was addressed to the additional deputy commissioner, Lordship. It is not the district commissioner. It means the departmental proceeding, the suspension was passed by the district commissioner, Lordship. And the entire departmental proceeding is done by the district commissioner, Lordship. But so far, which is stated by the petitioner in page 50, Lordship, it is submitted. It is submitted to the additional deputy commissioner, Lordship, and we are not found this letter, receipt of this, any evidence of the receipt of this letter in my record, Lordship.
Okay.
And now, Lordship, this is the stage of inquiry, Lordship. The allegation, the statement of allegation and the charge sheet was submitted, Lordship. Now, Ajay Chaudhary, what the principal referred by my learned senior, Lordship, it is from Ajay Chaudhary, Lordship.
You have a judgment of Ajay Chaudhary?
Yes, sir.
Anyone?
Yes, Lordship.
It is there, I think, my lord. If it is not, I can read it.
Not here.
Yes, last time I read both, my lord, Ajay Chaudhary and Salman.
Second file. Ajay Chaudhary.
Ajay Chaudhary.
It is here.
Paragraph 21, na?
Paragraph 21.
Lordship,
13.
I referred, Lordship. Paragraph 21, they referred. I referred paragraph 22. What is the fact? In the Ajay Chaudhary's case.
I think paragraph 13 is relevant.
Lordship, paragraph 13.
13, 90 days.
90, yes, 90 days. Now, Lordship, paragraph 22.
22
Yes, 22, paragraph 22.
of Ajay Chaudhary.
Yes, Ajay Chaudhary.
No, this is not Ajay Chaudhary. This is Ajit Sonwal.
This Sonal paragraph, my lord,
Paragraph 13.
Paragraph 13, original.
Ajay Chaudhary, 90 days principle was laid down in paragraphs 20, and I referred paragraphs 22.
Just a minute.
Yes.
Let me get all of that judgment.
Yes, Lordship.
If it's not there, you can just get a printout if possible. SCC. Ajay Chaudhary. Ajay Chaudhary. Do you have SCC of it?
Yes, we are getting mine.
You don't have. Oh, you have? Paragraph?
Lordship, paragraph 20 is the principle laid down for 90 days, Lordship. Paragraph 20.
20.
I refer 22.
Okay, let us see 20 first, then you go to 22.
Yes, Lordship. Lordship, 20, may I read, Lordship?
Yes.
It will be useful to to recall that prior to 1973, an accused could be detained for continuous and consecutive period of 15 days after judicial scrutiny and supervision. The Code of Civil Procedure 1973 contains a new proviso which has the effect of the circumstancing the power of the magistrate to authorize detention of an accused person beyond a period of 90 days, where the investigation relates to an offense punishable with death, imprisonment of life, or imprisonment for a term of not less than 10 years, and beyond a period of 60 days, where the investigation relates to any other offense. Drawing support from the observation contained of the division bench in Raghavar Singh versus State of Bihar, and more so the Constitution bench in Antule, we are supposed to extrapolate the questions of the proviso of section 197(2) CRPC 197 to moderate suspension order in case of departmental disciplinary inquiries. Also, it seems to use that if the parliament considered in nature necessary that a person be released for the incarnation after the expiry of 90 days, even though accused of commission of the most heinous crimes, heinous crimes, for which suspensions should not be continued after the expiry of the similar period, especially when a memorandum of charges charge sheets has not been served on the suspended
Okay, you come
person.
to 21.
Yes.
Come to 21 straight away.
Yes.
We therefore?
21. We therefore direct the
Currency.
that the currents of suspension order should not extend beyond the month if within the period of memorandum of
Not beyond the month, it's beyond 3 months.
Yes, beyond 3 months.
Yes.
Beyond 3 months, if within the period of memorandum of charge sheet is not served.
Yes.
That is the principle, Lordship.
Now, if it's served, then it should be, the reason order should be passed.
If submitted the charge sheet,
Two
then
things.
it is 22.
So, two things. One is if not served,
Yes.
then it
It
should
is
not
90
extend,
days.
it should not be more than
Yes,
3 months.
90 days, yes.
If it's served, then a reason order should be passed.
Yes.
If served.
Yes, Lordship, if served.
Then
reason order-
22.
Yes,
22.
22. So far as the fact of the present case are considered, now Lordship, consider the appellant has now been served with a charge sheet, and therefore these decisions may not be relevant to him any longer. In this Ajay Chaudhary's case, already charge sheet submitted, Lordship. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondent will be subject to the judicial review. Now, Lordship, charge sheet submitted. We have another OM, Lordship. Yes, we have another OM, Lordship.
Another what?
Yes, OM, Lordship.
What is that OM?
Yes. Copy for this. Copy is
This is in terms of Ajay Chaudhary only.
Yes, Lordship. Now, it is, yes, dated 4 February 2020. Fourth paragraphs. After issuance of the memorandum of charges of charge sheet, the seniormost secretaries shall undertake a review within 6 months of age regards to the disability to further continues with the suspension order. Now, Lordship, the review was made, and it was subsequently made.
So that is the last one. Anything else?
Lordship.
The last review.
Yes.
Last review was made on which date? Last review?
No, Lordship. Last review was made, Lordship. It is on
30 December.
Lordship. December. Yes. No. Last review was made on 10/3/2025.
Where is that?
March. Yes. This is in my record, Lordship.
Or not in the court's record?
No, Lordship. It is in my record, Lordship. So far from my record, it appears that
Which date you said? 10
yes,
March.
it is 10 March 2025, Lordship.
Extended to up to how much?
Lordship, it was till further order, until further order.
Okay. What is the permissible limit? 6 months?
Yes, Lordship.
As per the OM.
Yes, Lordship.
Now, when the last extension of the suspension
Is
was made in December,
13/12/2024. After that, Lordship, within 6 months, 10/3/2025.
it's not within 6 months, within all, I think, within 3 months.
Maybe, but
If you're going for 6 months, why you're going for 3
stated
months?
within 6 months. OM stated within 6 months.
It says within 6 months.
It may be 3 months, but within 6 months, Lordship.
All right. Yes, then?
Then, Lordship, the Ajay Chaudhary is not applicable here, Lordship. We duly reviewed, Lordship, the time to time, Lordship. and-
Ajay Chaudhary is not applicable because you have already reviewed
Yes, Lordship.
in December.
Yes, Lordship.
Then again in March you have reviewed. So Ajay Chaudhary is not applicable.
Yes, Lordship. Now,
And
Lordship,
regarding the information
yes,
that you say
regarding
that
the
we have not
information,
received, and this information was at any rate was given to additional deputy commissioner,
yes, Lordship.
but the suspension order was given by the district commissioner.
District Commissioner. Lordship.
So record does not contain anywhere
And
that we have received.
That this intimation was
Okay,
given
tell
by
me one thing.
22.
Tell me one thing, Mr. Goswami.
Lordship.
Does the record contain the reply?
Which one?
Reply to
Yes,
the show cause?
Yes, reply is.
Reply to the show cause is there?
Yes.
Then application for revoking of suspension is there?
Is
Dated 25th November 2024.
25th. Lordship, 25th is here, Lordship.
It is also there in the record.
25th. Just a minute, Lordship. 25th.
Reply to show cause is there?
Yes,
100%?
reply to the show cause is here, Lordship. It is dated 27/9/2024, Lordship. Reply
Okay.
to the show cause. Prayer for the petition 25/11
Is
here.
also there?
Yes, Lordship.
Okay.
Yes.
But that letter dated 22 August is not there.
Yes, Lordship. 22 August is not here, Lordship. And Rafed Ali Ahmed stated, Lordship, that from the date of information, 90 days will be counted.
What is that?
Yes, this is. Yeah.
The coordinate bench?
Yes, Lordship, coordinate bench.
Any separate decision apart from that?
No, Lordship, no, sir.
Not gone, it's not gone
Yes,
an appeal
no,
or something like that?
Still remain, Lordship.
Which paragraph?
Lordship, it is categorically stated, Lordship, regarding.
Paragraph
Yes.
20, is it?
It's 20, it is distinct, Lordship. A very pertinent question therefore arises as to from which the period the direction. 20, Lordship. Yes.
Brings the fact to the knowledge of the employees, brings the fact that
Yes.
he or she has been released from so this is the date.
Lordship, please kindly see page 14, Lordship.
Huh?
14 in the Rafet Hussain, Lordship. Now the yes.
Rafet Ali Ahmed.
Yes, Rafet Ali Ahmed, Lordship.
What page 14?
Page 14, Lordship. 14 out of 15, Lordship.
Paragraph number?
Yes, paragraphs, Lordship, it is 20.
20.
Relevant portion is 14, Lordship. Page 14. Second part of that paragraphs. Now the question.
Yes, read.
Now the question arises that when the above mentioned conditions can be taken into consideration by the appointing authority, in the opinion of this court, the conditions above noted can only be taken into consideration when the delinquent officer / employees, being the fact that he / she has been released on bail or otherwise, not in any custody or imprisonment, to the appointing authority who has the power to vacate the suspension order. Lordship, they submitted before the ADC. ADC is not the appointing authority or the power to revoke his suspension, Lordship. And deputy commissioner, only district commissioner is the power to revoke his suspension, Lordship. Therefore, this judgment is very clear that he must intimate his release before the appointing authority who has the power to vacate the suspension order, Lordship. Huh? Of course. I will do my April, December course with a March of course. আমি হেৰি যেতিয়াৰ পৰা হেৰি দিছো তেতিয়াৰ পৰা
All right. Yes.
That's all.
That's all.
Yes.
And any reply?
I think, madam.
I think we can dispose of this writ petition.
Yes, sir. madam.
Anything remains? Your specific challenges regarding your prolonged suspension.
Yes, prolonged suspension.
Whatever inquiry is going on,
Yes,
that's a different chapter.
Yes, that is the different chapter. madam. And my only case, my daughter, your lordship country is Ojoy Chaudhary, other things, and thereafter 2 judgments has come before this on court coordinated. Ojoy Sanwal is your lordship handy. It was on 22/3/23.
That's on the basis of Ajay Chaudhary.
No, Ojoy Chaudhary is earlier. But what I am saying, my lord, this Ajit Sanwal was decided on 2/3/23 after the office was burned down. You have a kindly note, my lord. 2/3/23.
Ajit Sonwal.
Yes.
Okay.
Yes. Decided on 2/3/23. Your lordship got it right.
Yes, yes, yes.
Another judgment, your lordship, that I am giving, decided on by coordinated bench on 24/7/24.
But is it necessary?
Just I am giving, madam. Yes.
It'll create more confusion.
No, this it says, madam. Just
The main thing is Ajay
Yes.
Chaudhary.
I did your lordship.
On the basis of Ajay Chaudhary, that OM has come.
Yes. There,
So-
after OM, 2-3 judgment are there. They have said that now 90 days must file. That is I am given, madam.
No, even then, Lordship.
Ojoy Chaudhary, just have a look to Ojoy Chaudhary paragraph 13 and this one, madam. Just now I have given, madam. 24/4. A high rate person, madam. Just this one. Honorable Justice Sanjay Madi, madam. It was decided on 24/7/24. Yeah.
Even then,
Coordinated.
if we go through the Rafel Ali Ahmed, and if we go through our reviews, the decision of reviews, Lordship, it appears that we are doing as per laws.
That is
All right.
Yes.
Obliged to yours.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. A.H.M.R. Chaudhary for the petitioner. Stop also had Mr.
J.K. Goswami.
J.K. Goswami, learned
Additional
senior government advocate for the respondents. Stop having regard to the nature of case projected by the petitioner. Comma, the writ petition is taken up for disposal at this stage. Stop next paragraph. By filing this writ petition, the petitioner has challenged.
May I go my heel with you?
Sure.
And some other court is calling.
You're going back to Silchar?
No, I
Okay.
come back from Silchar.
Okay, you just come back.
Come back, man.
All right,
Okay.
yes.
You will be here.
By filing this writ petition, the petitioner has challenged the order dated 18/6/2024 and 13/12/2024 by which he has been placed under suspension with effect from 12/6/2024, pending departmental proceedings against him and the extension of his suspension period respectively. Gustav, it is the case of the petitioner that after being suspended as such, he has not received the subsistence allowance.
My lord, he is receiving subsistence allowance.
At the increased rate of 75%. You have not received the increased one.
Yes.
Allowance you have received, but the increased one you have not received. And therefore prays for a direction to the respondent authorities to reinstate him back into service. So the petitioner contends that after being released from custody, he informed the respondent authority concerned by writing a letter on 22/8/2024 and thereafter a reminder on 21/9/2024. Stop. Despite the same and despite passage of 90 days from the initial date of his suspension, the respondent authority has not reinstated him into service in violation of the apex court decision rendered in the case of Ajay Kumar Chaudhary versus Union of India and another, reported in 2015 7 SCC 291. Top, the learned senior counsel for the petitioner has submitted that against the show cause notice given to the petitioner, along with the memorandum of charge and the list of witnesses on 19/9/2014, 2024, sorry, 19/9/2024, comma, the petitioner submitted his reply to the show cause notice on 27/9/2024. And thereafter, another letter on 25/11/2024 for revoking his suspension. To stop, the learned senior counsel submits that the petitioner had also intimated to the authority concerned in his show cause reply that he had submitted his release order by courier. And therefore, the respondent authority concerned ought to have taken proper steps in terms of his communication dated 22/8/2024. Stop. Despite the same, the respondent authority denied receiving such communication, and except for the reminder dated 21/9/2024. While passing the no and proceeded to pass the impugn order dated 13/12/2024, extending the period of his suspension until further orders. Stop. The learned senior counsel therefore submits that the decision of the apex court in Ajay Chaudhary Supra and also a decision rendered by the coordinate bench of this court. No, a decision rendered by a division bench of this court in the state of Assam and another versus Ajit Sonowal and 3 others, reported in 2023 0 SC. I'm sorry, I'll repeat. Reported in 2023, then 0, then Supreme, then within bracket GAU 199. Being violated by the respondent authority, the petitioner should be reinstated back into service. And the increase in subsistence allowance, which was denied to him, be also paid to him. Next, para Mr. J.K. Goswami, learned additional senior government advocate, on the other hand, submits that the communication dated 22/8/2024 was not only not received by the respondent authority concerned, but the same has been addressed to the additional deputy commissioner, personal branch Kachar Silchar, which is not the authority who had issued the suspension order. Full stop. The petitioner has only brought his release from custody by his communication dated 21/9/2024, and by which time the order dated
13/6/2024. 13/12.
How can it be 13/12? 13/12 is later on. Isn't it?
Lordship. The review order, Lordship.
Yes.
It is 13/12/2024.
What did I say? Last part. Had received only. Something wrong here.
Lordship,
You are aware about you are aware about his release on 21/9. 21/9 you have received, isn't it?
Lordship.
But the extension of suspension came to be passed in 13 December.
Yes. Yes, within 3 months.
Within 3 months from
Lordship, it is 21 September, Lordship. 21 September,
yes.
October, November, and December, Lordship. December 10, Lordship. 21 September, October, November, December, Lordship. 21 December will be the 90 days, Lordship. We reviewed on 13, Lordship. 13 December.
What did I say? Please read the sentence. Full stop जाओ खाना चाहिए पहले. And by which time you can cancel that. And therefore, the period of 3 months' time will count from that date. So accordingly, the continuation of the suspension order was passed on 13/12/2024, which does not call for any interference by this court. Stop. The learned State Council also submits that as per the records which he has been furnished with, further suspension order has been passed
10/03.
on 10/3/2025,
Yes.
which is until further orders. Stop. The learned council, the learned State Council referring to paragraph 22 of Ajay Kumar Chaudhary, Supra, submits that when a charge sheet has been served, the direction for non-extension of suspension period beyond 3 months is no longer relevant, which has happened in the instant case. Stop. He submits that in terms of the apex court decision in Ajay Kumar Chaudhary Supra, the government of Assam, Department of Personnel, Personnel B within bracket, had issued an office memorandum dated 4/2/2020, which provides that after the issuance of memorandum of charge / charge sheet, the senior most secretaries shall undertake a review within 6 months as regards the desirability to further continue with the suspension order. Stop. The same has been duly complied with in the instant case, and thus no interference of the court may be called for at this stage. Next para, I have heard the submissions made by the learned counsels for the rival parties, and I peruse the materials available on record. Facts not in dispute is that the petitioner was placed under suspension by order dated 18/6/2024 with effect from 12/6/2024,
Lordship,
comma,
regarding Rafet Aliam, I also paragraphs 21, Lordship. Lordship, paragraphs 20, Lordship. Last portion, Lordship.
okay. I've heard Kati Makan mo belle me asirahan. The learned state council lastly submits that he places reliance upon the case of Rafet Ali Ahmed versus State of Assam and others, reported in 2023, 3 GLT 718, wherein a coronation bench of this court has held that
Paragraph 20, Lordship. Last portion.
the period of 3 months from the date of release of bail or from custody or from imprisonment would count from the date the employee oblique officer concerned brings the fact of his oblique her release to the appointing authority who has the power to vacate the suspension order. Next. Facts not in dispute is that White order dated 18/6/2024. The petitioner was placed under suspension with effect from 12/6/2024. That is the date of his arrest, pending withdrawal of department proceeding against him. Thereafter, the petitioner was given a show cause notice under Rule 9 of the Assam Services, open bracket, Discipline and Appeal, close bracket, Rules 1964, read with Article 311 of the Constitution of India. To show cause by submitting written statement of defense within 10 days from the date of receipt of the communication. Along with the show cause notice, statement of allegation against the petitioner. And the list of witness was given to him. The petitioner submitted his reply to the show cause notice on 27/9/2024. Thereafter, he also submitted a letter dated 25/11/2024 seeking revocation of his suspension. However, the respondent authority concerned, bracket respondent number
Two, Lordship, 2.
issued the impugn order dated 13/12/2024, extending the suspension period of the petitioner until further orders. Although the petitioner has maintained that he had intimated about his release from custody on 22/8/2024 to the Additional Deputy Commissioner, Personal Branch, Kachar Silchar, wherein the seal and the receipt number and date was also endorsed by the receiving authority, the respondents have denied receipt of the same. Mr. J.K. Goswami, London State Council, submits that in the record which has been furnished to him, the same is not available. He reiterates the fact that the petitioner's release from custody was received only on 21/9/2024 when he sent a reminder. Stop. The same is available in the record. Next para. Coming to the decision relied upon by the parties, it may be seen that the apex court in Ajay Kumar Chaudhary at paragraph number 21 has held that the currency period of suspension order should not extend beyond 3 months if within this period, the memorandum of charge / charge sheet is not served on the delinquent officer / employee. Stop. However, if the memorandum of charge / charge sheet is served, a recent order must be passed for the extension of the suspension. Stop. At paragraph number 22 of the said judgment, as already noticed herein above, the apex court in the facts of that case held that since the appellant had already been served with charge sheet, the direction given in paragraph number 21 may no longer hold good. Stop. Under the circumstance, the appellant may challenge the continuous suspension in any manner if so advised and in accordance with law. Stop. A coordinate bench of this court. No, stop. Cancel that. Similarly, a division bench of this court in State of Assam and another versus Ajit Sonowal and 3 others, Supra, had relied upon the decision of the apex court in Ajay Kumar Chaudhary, Supra. Next para. Further, a coordinate bench of this court in Rafiq Ali Ahmed, Supra, had also held that the period of 3 months as prescribed in Ajay Kumar Chaudhary, Supra, would count in case of an employee who is arrested from the date he brings to the notice of the appointing authority to revoke the suspension order the fact about his release from custody. Stop. Next para, coming back to the present case. Although the respondents have taken the stand that the communication dated 22/8/2024 submitted by the petitioner to the Additional Deputy Commissioner, Personnel Branch, has not been received. But it was only the reminder dated 21/9/2024 which was received. And therefore, counting of 90 days would begin from 21/9/2024. Stop such being the case, the extension of the suspension order 13/12/2024 is only in order. Stop. However, the fact remains that the reply to the show cause notice dated 19/9/2024 by the petitioner on 27/9/2024 which was addressed to the Deputy Commissioner, which was addressed to the District Commissioner, Kachar, Personal Branch, Silchar, states that the petitioner submitted his release order and courier receipt copy to the said authority via application dated 22/8/2024. Stop. Likewise, the subsequent letter submitted by the petitioner on 25/11/2024 before the respondent number 2 comma, the petitioner has referred to his previous show cause reply dated 27/9/2024. Stop. Such being the position, it is clear that the petitioner had informed the respondent number 2 about being released from custody. Stop. Although the communication dated 22/8/2024 may not be addressed to the respondent number 2, but the fact remains that the show cause reply as well as the communication dated 25/11/2024 is indeed addressed to respondent number 2. So therefore, admittedly, the impugn order dated 13/12/2024, having not been passed within the time frame of 3 months, as stipulated in Ajay Kumar Chaudhary Supra, and also in view of the decision in Rafet Ali Ahmed Supra as well, the same is found to be not sustainable and accordingly set aside. Stop. The subsequent order of suspension said to have been passed on 10/3/2025 shall also be vitiated in view of the observations and direction made here and above. The respondent number 2 is directed to reinstate the petitioner immediately. Then the respondent number 2 shall also grant the petitioner the increase in subsistence allowance which remains unpaid to him till his reinstatement. Stop. Needless to say that the other benefits that may be entitled to the petitioner shall be governed by the order to be passed once the proceeding drawn against the petitioner is concluded. Next para with the above observation and direction to petition starts this program.
Time bound period, my lord, for reinstatement.
Immediately. Okay, instead of immediately, you say within 15 days from the date of receipt of a certified copy of this order.
Definitely.
This is item number 34. Ah, 52. Yes, 52. This is your case?
Yes.
Review.
Yeah.
Review.
Lord,
Who has filed the review?
My lord,
Who has filed the review?
my lord,
The petitioner.
petitioner, yes.
Petitioner. Why?
My lord, I have filed that particular.
What is the ground?
petition challenging the suspension order. My lord, may kindly have a look at my lord, page 16, my lord.
No, you tell me what is the ground for review?
My lord, while allowing my writ petition
Ah.
and by revoking the suspension order and directing me to reinstate,
Ah.
then my lord may, my lord have observed that it is however provided herein that the petitioner's entitlement is restricted to the amount of subsistence allowance drawn by him.
Okay, now what has happened?
My lord, thereafter, my lord, they have passed an order and, my lord, page 17, my lord.
You have been cleared.
My lord,
You have been cleared. You have been reinstated.
been reinstated.
And what about any penalty imposed upon you?
No, no. not
No
yet.
penalty.
No penalty.
You have been exonerated.
No, it's going on. The disciplinary proceeding is on.
So what is your claim then?
My lord, what had happened, my lord, while thereafter, my lord, they have published a notification, page 17, my lord, whereby they have the suspension order number so and so in respect of petitioner so and so is hereby revoked with immediate effect, and the period of suspension shall be treated as period on duty for all purpose of service and pension benefits. Thereafter, they have mentioned, however, his entitlement is restricted to the amount of subsistence allowance drawn by him.
Okay, so DP is not yet over.
DP is not.
You are reinstated, but it is continuing. So ultimately, it will be decided.
No, my lord.
What is the
I am not on
problem?
that. My lord, thereafter, my lord, what had happened, my lord, as the lordship.
See,
has passed-
ultimately, let's listen. After the departmental proceeding is concluded,
Yes.
and in the event they exonerate you, you will be entitled to get all the benefit. But till then, you will only get that subsistence allowance already drawn by you. That is what the court meant.
No, my lord, what had happened, my lord, for 3 months, my lord, I was for the, during that suspension period,
Hmm.
for 3 months, my lord, I was getting 50%.
Yes.
Thereafter, I was getting 75%.
Okay.
So, my lord, now, my lord, after passing of the, my lord, passing of this order, my lord,
Hmm.
where my lord lordship has observed his entitlement is restricted to the amount of subsistence allowance drawn by him. That means, as per my understanding, my lord, I am entitled to the remaining 25% and another 50%.
Okay, 50 and 25%.
Yes.
These
and-
things you will be getting it once you are exonerated. If you are not exonerated, then
But my lord, may kindly see there, my lord, notification, my lord, page 17, my lord.
period on duty.
Yes,
This is what you meant.
yes. They have
Period on
mentioned-
duty. If I'm on duty, if I'm treated to be as on duty, I should get full allowance. I should get the salary.
At least, my lord, I am entitled to that, my lord, remaining, my lord, 50% and 25%.
So what happens actually once a proceeding is done? Listen, please listen. Once a proceeding is done, you are suspended. You are entitled to 50%, 75% or whatever increase it may be. Until the final order is passed. Correct? Now the final order comes and the disciplinary authority says that no, there's nothing wrong with this thing. He's exonerated. Then what happens? What is your entitlement? Will you not get back that amount?
Get back. But, my lord, as per their order, my lord, they have already mentioned, my lord, suspension order is revoked with immediate effect, and the period of suspension shall be treated as period on duty. Already they have considered as my period on duty.
But for the observation, you're not getting it.
Yes. But that's why, my lord,
What do you say?
pray for a, my lord, clarification on this.
My lord, it is complying with your lordship's order. It
Yes,
says
then?
that it will be treated on duty because some pensionary benefits are also counted for those months of suspension. Then my lord had held that because he was under suspension, he will be entitled to subsistence allowance, and therefore even after his reinstatement, what he will get is subsistence allowance for the period of his suspension. Post that, my lord, he will be given his regular salary. But when he was not on duty, my lord, the subsistence allowance is all that he will get, and that's
But
what
you have treated as period on duty.
That's why, my lord, I pray for a with clarification.
You could have said that for the as on duty for his pension and benefits.
the simplicity of
You are
my lord,
saying
we
that
have
for the
given.
purpose of service also. Everything. You're giving everything.
But that your lordship's observation is also given at the end as a clarification. It is given that.
I don't know. See whether how things are to be looked into. But the thing is that you have treated the suspension period as on duty. You should have clarified as for the purpose of this or that. You have just simply covered everything for the purpose of service and pensionary benefits. So I think he'll get his seniority also. And all the benefits he'll get.
But your lordship's order says gives that restriction, and based on that, my lord, the final sentence, my lord, should prevent.
The order of this court said restricted to the whatever has got the subsistence allowance regarding the money.
Yes.
But there was no restriction drawn that how you should do it. But only thing is that you have given him everything, saying that for service also, for pension also, will be counted as on duty. So you have contradicted yourself.
And perhaps petitioner is also contradicting because they are saying I have received everything, but I have not received everything. That is what they are trying to say.
Is receiving everything, but
They are giving me everything, but they are not giving me everything. Essentially, that's what the petitioner is trying to say through this.
but before that, something is to be overcome. What is that?
In my view, my lord, there was no infirmity in your lordship's order, and that needs
No,
to
no,
be
that is
complied.
another thing. There's another technical issue. What is that?
Here, my lord, it says shall be treated as on duty.
This order sought to be reviewed is passed on which date?
7/10/2024.
No. 12/9.
Yes.
Order to be reviewed.
Yes.
You're not seeking review of order passed by the department. You're seeking review of the order passed by this court.
No, I am seeking, my lord, please have some clarification on
No,
that
no,
part.
forget about clarification, whatnot. I'm asking you a question.
Yes.
You are seeking review of which order?
12/9.
Passed by this court or passed by the department?
By this court, my lord.
So see that. Say that. So order was passed on 12/9.
Yes.
When did you file review?
My lord, review was filed on, my lord,
28 February.
yes.
So what has happened now?
My lord, after, my lord, this notification, my lord. their
Article
notification
123
I
or
pray for-
132? Limitation Act,
Well, it's a repetition, my lord.
maybe a writ petition, but will apply. Spirit will apply. Is there any whisper in your application that because of this, I could not file within 1 month? There's a division bench judgment of Bombay High Court also. The other day, somebody had referred to it,
Well, I
wherein
don't
it said
think
that
because
per se,
not
this,
specific.
per se 226, in 226, this order 47, I think, section 114, 115
Yes.
will not apply. But that does not preclude that person from explaining the delay. What? Because it is a public policy that one should file within 30 days. If you say limitation does not apply, then what will happen?
Yep.
20 years, 30 years back, some order was passed, today you will come and say, please review this order. Is it possible?
No, my lord may kindly appreciate one thing. Lordship has observed. My lord, it is however provided herein that petitioner's entitlement is restricted to the amount of subsistence allowance drawn by him.
Oh, that I've understood. I'm talking about delay. We'll dismiss your review petition on delay. Now you'll say, I have filed under the chapter 10 of High Court rules.
Yes.
There is no limitation.
Yes, my lord.
This kind of submission we have heard earlier. At least you should have few lines explaining that this delay was because of this or that. Then we could have ignored it. You have not done anything. You took it for granted that you'll file any time, court will review it or dismiss it on merit. You have failed to consider about the delay part. So, we'll dismiss it.
Saturday, my lord. Let me go through, my lord.
Huh?
I need some home. I need to do a bit homework, my lord. on
What
this.
kind of homework?
My lord, on this issue, my lord, because I have filed it under chapter 10.
10. See, the concept is like that. If you say that there is no time limit, then like I said, it'll be a big problem. People will come after 15, 20 years, 30 years. Please review. Why? Because there is no limitation. Open the Pandora's box. What do you want to do?
My lord may have it on some other day, my lord. In the meantime, I will go through, my lord, so that if I can.
This is a review.
That is also.
The bench is available until next week. What do you want to do? Okay. How much time?
A week's time, my lord.
Huh?
A week's time, my lord.
1 week. As paid for by the petitioner, matter stands adjourned for a week. You just figure out what to do. I'm not giving you any
Okay.
tips and all that.
May it please, Lord. Lordship, can you take up the matter at item number 12 first? Item number 12.
Item number 12 is your favorite.
No, Lordship, it will dispose the earlier case first.
I see.
No.
What is this matter?
Page
For
number-
disposal or
Disposal, Lordship.
for your taking time?
No.
Anyone taking time?
No.
No one is taking time.
11 is infructuous, my lord.
Lordship, yes, Lordship, kindly take.
11 is infructuous.
Not infructuous, I will say, Lordship, kindly take the matter, item number 20.
And Lordship, then this may be hard Lordship in presence of.
My friend as thus is looking after this matter also.
As thus.
As thus. So he left the court for some personal reason.
Lordship,
If he wants to say that, I'll.
Why? He convinced you?
Lordship,
Within 1 second, he convinced you.
Lordship,
You were
can you
seeking
see the
it from-
page number 21, Lordship, in item number 21.
Item number 12.
12, Lordship.
Page
Page 21.
21.
This is pair person, Lordship.
What is this matter? Just tell me. in two-
Matter is,
two lines.
Lordship, regarding this challenging the OM, UGC regulation.
Sorry?
UGC regulation.
UGC regulation.
UGC regulation as well as OM, issued by the Director of Higher Education for appointment of assistant professor.
Okay.
Earlier 2018. In this OM, and some irregularities there, some petitioners have come before this court. And along with the one issue was there that
Who are you?
I'm the aspiring candidate for the assistant professors.
Assistant professor.
Professors in defined discipline.
Assistant professor is the entry grade,
Yes, yes.
isn't it?
Yeah, yeah, yes. It's
Entry
a-
grade.
Entry grade.
So are you saying that the UGC regulation has not been followed?
Followed.
It has been followed,
Followed that time. Not followed.
not followed.
Not followed. That therefore the aspirant candidate has come before this court.
No, according to you, UGC regulation is not followed.
Not followed.
Okay.
Right. And along with other pair was there that the candidate, some candidates have been overaged.
Overage.
Then that
You have been rejected.
not rejected, but
Your application was rejected.
no, application was pending that time.
Now
Now
what has happened?
Therefore, Lordship, kindly see page number 21. Pair person, Lordship, 5. Lordship, Roman 5.
Yes.
A writ in the nature of mandamus shall not be issued declaring and holding that the petitioners are entitled to participate in the selection process for selection of assistant professors in provincial colleges.
Mm.
Therefore, thereafter, in this case, Lordship, in
And
order,
when did you want to participate? Which year?
yes, Lordship, in
Which year?
2018,
2018. Your writ petition of 2019.
Lordship.
So is there anything
Yes,
remaining?
Thereafter, Lordship, some candidate has participated and some candidate has selected. After selection, Lordship, age condemnation point was come to the before this court, and therefore item number 11 was filed. That is filed by me. That I have been selected as per the interim order. I have appeared and I have selected for the post of assistant professor. And in the meantime, Lordship, government has condemned my age relaxation. I have been appointed. So item number 11 become infructuous, Lordship.
Item number 11 is the private respondent
My lord.
in item 12.
No, my lord, I am appearing in
This is my appointment letter.
item number 11 for respondent number 6. That is the college, ADP college.
Which was, what was filed first? Item 12,
Item 12.
the first case.
First case. Then there's only 2 candidates has been selected because 23 aspirants was there, but other had not been selected, and there are some two have been selected, and two are overaged candidate.
How many petitioners are there?
Petitioners are there 23,
24.
24. But rest are not selected.
24 petitioners were there,
Yes.
are there.
There.
And your prayer is to consider to allow you to participate in the selection process.
Yes, participate. But some of the participate and
Hmm. You have been allowed to participate,
participate, Lord.
and all of them are successful.
No, Lord. Only 2.
Who are they?
Who are now repetition number 11, Lordship,
11 and
and as well as 13, Lordship.
11 and 13.
11 and
After
13.
interim order passed in the other petition, only these 2 candidates, they have been selected by the selection committee. But government has not given appointment solely on the ground that on the date of application, they were overage.
Who? 11 and 13.
Yes,
They were overage.
overage.
So
In the meantime, in respect of 11, government has condoned the delay and appointment order has been issued. Only remaining is item number 13.
Lordship.
item number 13.
13, Lordship.
What is 13 for?
In respect of item number 13,
What is 13 for? See, let me try to understand your case.
Lordship, I'll try to.
Item 11 No, item 12.
Lordship, kindly take up item 13, it will clarify, my lord. I'll try to.
No, just a minute. Item 12,
Yes,
which was just submitted by your friend there.
yes,
There are 24
yes.
petitioners. And one of the prayer was that you should be allowed to participate in the selection process for the post of assistant professor
Yes.
in provincialized college.
At that
And
time,
you were allowed.
at that time, there was a OM of the government which was not in conformity with the UGC regulations. So
Hmm.
that was put to challenge in that earlier writ petition, WPC 5998 of 2019. In that case, there was an interim order passed. That
Dated?
interim order is dated 21st of August 2019.
Yes,
Lordship has got it, my lord.
yes.
The operative part, next page, my lord.
Why you were debarred otherwise?
Lordship,
Why you were debarred?
debarred in the sense that some of them were overage and on the verge of completing 38 years of, and second ground was taken that the OM which was under challenge was not in conformity with the UGC regulations.
What is that? Not conformity.
The marking patterns of the 2018 office memorandum, which was framed by the education department, was not in conformity. In that case, this interim order was passed. So the petitioners were allowed to participate. However, may I read, my lord? This court is of the view that the aforesaid issues can be examined after the respondents file their affidavit. However, in order to protect the interest of the petitioners may be allowed to apply for the post of assistant professors as advertised by various colleges in the state of Assam. However, their candidature and selection, if any, shall be subject to the result of this petition.
Okay, before that, read according to the petitioners, same order, read.
Lordship?
You are reading the order dated 21/8.
Yes, yes.
You read from the 1, 2.
According to the petitioners, the state
Yes.
government issued an office memorandum on 8/11/2018 by which they have laid down selection procedure for appointment to the post of assistant professor librarian, which according to the petitioners are not in conformity with UGC guidelines. For example, though UGC guidelines had not provided any specific minimum age of applicant, under the office memorandum, the maximum age has been fixed at 38 years for general category with relaxation provided for other categories. It has also been stated.
Yes.
It has also been stated that the aforesaid office memorandum undue advantage is given to the candidates who had recently passed out in their HSLC examination, and most of the petitioners has completed their HSLC examination long before. Further, as per UGC norm, at least 25 marks are to be allotted to candidates who possess PhD degree. However, under the aforesaid office memorandum, only 9 marks have earmarked, thus putting such candidates having PhD degree in a less advantageous position.
So are you having PhD?
Yes.
And how does this matriculate come into picture?
Which one, ma'am?
Those who have recently passed HSLC.
Because that OM has now been again superseded by another OM. So to that extent, this writ petition, the challenge to the writ petition is now gone, my lord. What happened? Pursuant to this order passed by this court, only 2 persons have been selected. One is the petitioner in item number 11 and petitioner in item number 13. The petitioner in item number 13 was petitioner number 21 in the said writ petition.
21.
21.
Okay. But last time, just now, you said 11 and 13 are selected.
That is 11 and 13. 13 is the writ petition filed by petitioner number 21 in the present writ petition. Same petition.
No, 13 is Gautam Kumar.
Item number 13 is the petitioner.
No, see, who got selected? Give me the names. Only 2 persons.
Page 20, which page is Lordship looking at?
No, amongst the 24 petitioners
Yes.
in WPC 5998.
Yes.
Who are selected? Dr. Padma.
Nirmali kiman ase? Petitioner number 21. Nirmali control.
20 and 21, I think.
And 20 and 21. Nirmala Devi, no? Nirmala Devi.
Okay, 11 and 13 was regarding item number.
Item number, Lordship.
Okay.
Yes, yes, yes.
Hey,
That's
confusing the court. Item number, and I was looking at the petitioner number.
No, I was talking about the item number. Sorry, my lord. It was my
So,
mistake.
petition number 20 and petitioner 21 are selected.
Yes,
They also have filed a case.
yes. Now, my lord, after this interim order was passed,
Acha, this interim, yes. Then
the lordship takes up that item number 13 will clarify, my lord.
13.
Item number 13.
13 is WPC?
WPC 3312 of 2020.
Yes. What about this?
Lordship has already gone through the interim order passed by this court, which Lordship will find at page 21 of the writ petition. 3312.
Yes, in item 3312, what is there to be seen?
Lordship has taken item number 13, my lord.
Yes, item 13.
Item number 30 at page 21.
Just a minute, okay. Item 13, then this is 12. This is 11. Yes.
Lordship has already, page 21 is the order which Lordship has already seen.
It's the next year also?
Yes. It will
21.
clarify, my lord.
Yes, then?
Then this order was not complied with. Even after this order, these petitioners were not allowed to participate.
Okay.
Then Lordship kindly turn to the next page, page 28. The petitioners filed an interlocutory application
For
issuing. There, my lord, this court, honorable court, has passed an order, page 34, Lordship. I'm reading from the second paragraph. May I read, my lord?
Yes.
Learned counsel for the applicants submits that though the applicants have been allowed to apply for the post, they have not been allowed to take part in the recruitment process which is going on because of the reason that the Director of Higher Education has not forwarded the copy of this order to the respective colleges. So this court fails to understand how the principals of various colleges would avoid the order of this court on the ground that the same has not been communicated to them by the director when the same has been communicated by the applicants petitioners to them. Considering the submissions advanced by the learned counsel for the applicants, the applicant may file appropriate application before this court as to why concerned principals did not comply with the direction of this court, so that appropriate orders can be passed in such proceeding.
Meaning was contempt.
Lordship, thereafter, in view of this order, Lordship will kindly turn to page 20 of the writ petition.
Page 20.
Page 20.
Yes.
The order of this honorable court was communicated by the director to all the principals. May I read, my lord? Regarding.
When? After this order?
Yes, yes, yes.
In September?
Yes. 3rd of September.
Yes, then after that?
After that, the petitioners were allowed to participate.
Okay, then?
In the meantime, my lord, advertisement was issued. That advertisement will Lordship find at page 17 of the writ petition.
17, yes.
The petitioner is concerned if your Lordship turns to the next page, page 18, serial number 3, economics. 3 posts, 2 posts were unreserved. Petitioner was interested in 1 post of unreserved for economics. Earlier, the petitioner was not allowed to participate. In view of this order, the corrigendum was issued. The corrigendum will Lordship will find at page 35.
Corrigendum of what?
That the petitioner were allowed to participate. That corrigendum Lordship will find type copy at page 35. In pursuance with the order of the Honorable High Court passed in dated 21/8/2019 in WPC number 5998/19 dated so and so and passed in so and so, so and so. And reference is also made to the DH's letter dated 3rd of September. All eligible candidates are requested to apply, keeping sequence with the terms of the conditions laid
Okay,
down.
got it then.
My lord, pursuant to that, page 37, Lordship will see. Call letter was issued to
Yes,
the
then
petitioner.
call letter
Call letter,
to everyone,
page 37, my lord.
to everyone.
No, that to the petitioner. Petitioner was interested in that college, my lord.
Okay.
Amongst others, to the petitioners also it was issued.
What about the other petitioners like Nirmala Devi?
They were interested in different colleges.
Different
not
college.
Different colleges, my
Okay.
lord, yeah. Not in this college. In this particular college, call letter was issued to the petitioner.
Okay, then
And if your lordship turns to the next page, page
Report.
38, the recommendation of the selection committee. This is dated 12th of October 2020. With the following members of selection committee, may I read, my lord? With the following members of the selection committee for the selection of assistant professor, Department of Economics, Padmanath Gohai Borua Government Model College, Kakopathar, interviewed 12 out of 29 candidates who came for interview for unreserved post in economics on 12/10/2020 from 9 a.m. in Tinsukia Commerce College. After interviewing the candidates, duly verifying the academic records and other testimonials, we have unanimously selected 1 Dr. Azizur Rahman, 2 MS Sampurna Bhuya. This is the petitioner.
correct. So
It was recommended. Thereafter, the next page, GB has taken the resolution and forwarded to the DHE for appointment. Lordship has got it, my lord, page 39.
yes,
But till then, my lord, the petitioner has not been, a formal appointment letter has not been issued.
why?
Because according to the authorities, on the date of application, petitioner exceeded 38 years of age.
What is the minimum limit, maximum?
Maximum is for general category 38, my lord.
Hmm.
But in the meantime, petitioner has also filed an application for condonation of delay. That is at page 41.
So if there's a bar, then how can he get appointed?
Now, my lord, petitioner was allowed to participate by way of an order of the court.
Maybe.
Now, but the thing is that.
But if the regulation says that you cannot be beyond for 38 years, then
But a similarly situated candidate, item number 11 has already been issued, my lord, appointment order. That has been placed before.
how is that?
May I, Lordship,
On what basis?
how it has been condoned by the government, so
So if it can be condoned, that means
it can be condoned, but provided they have filed a representation before the authority, then they will examine it. Then if it's possible, then.
It's already there, my lord. That can
so
be
page
taken.
41 is there, representation.
Yes, that is there.
Then we'll consider the representation within a Lordship specific time period, because automatically it will not, because the government, at page 44, the provision is there how to relax.
Page 44
of item number 13. 3312.
item number 13. Okay, page number 44.
44. General rules for relaxation.
Please read. What does it say?
General rules for relaxation. It's of 3/5/1951, this notification.
Oh, 1951 notification.
Yes. On the basis of this, the item number 11, the candidate of the item number 11 has been condoned. Lordship, age has been condoned. So, Lordship.
So in respect of this writ petition, that observation can be made.
Yes, my lord.
And what about the others?
No, in petition number, Lordship, WBC 3312. 3312, Lordship, item number 13. They may file representation once again, Lordship.
I have already filed, my lord. On the basis of that.
Since it was Lordship, even if they have filed in 2021 at page 43.
Yes, you
So
file one more.
Let them, Lordship, file a fresh representation before the government, that is the secretary. Then it will be examined as per the merit, if required.
Secretary, which secretary? Higher education.
Higher education department. This is the government. As per
What is the nomenclature now?
Secretary. This is the secretary.
Secretary.
Yes, sir.
Okay, that takes care of 3312 writ petition.
Yes, sir.
What about the others?
And 2725, Lordship, already has been
Huh?
an appointment has been done.
Item number 11, my lord.
Item number
11 is infructuous.
My lord. According to.
Maybe dispose of such. Yes. Appointment has been given. My
Hasn't considered.
Heard Mr.
D. Mahanta.
D. Manta, learned counsel for the petitioner, who submits that the writ petition has become infructuous since the petitioner has got the relief.
13.
Who appears, Mr.?
T. Chakraborty for item number 13.
No, in 11.
He is higher
Higher education, for higher education, I am okay.
Mr.
A.R. Tahbildar.
A.R. Tahibildar, learned counsel, learned standing counsel, Higher Education Department, appears for the department concerned and agrees to the submission. In view of above, WPC number 2725 of 2022 is disposed of as infructuous. Registry to detach the same from the remaining bunch of cases.
My name may be recorded, my lord.
Okay, one minute.
For respondent number 6.
Sorry? Name?
Sharma.
Mr. A.J. Sharma, Mr. A.J. Sharma, learned counsel, appears for respondent number 6 and also agrees to the submission. So in view of above, then the other one, 13. What about 12?
12 already, my lord, the prayer made is not surviving cause of action in view of the fact that the OM which was under challenge is not in force as of now. So,
Okay, we'll go one by one. Just a minute.
but one observation is required, my lord. The pursuant to the interim order passed in that petition, petitioner was allowed to participate. That may be taken care of, my lord.
He participated then, but he could not make it.
No, he made it, but government is not appointing. The appointment order has not been issued.
Age has not been condoned.
No, in item 12. I'm talking about item 12.
In respect of item number 12.
13th, though, we'll ask him to file. We'll ask you to file a representation. They'll consider.
Yes.
Then item 12, what will happen?
Item 12 is also become infructuous in view of the fact that OM which was under challenge is not in force as of now. But the
Which
thing is,
OM?
in view of the interim order, my prayer is that in view of the interim order passed.
You were allowed to participate.
Yes, I was allowed. That may be taken care of.
I understand, but where is the OM? Show me the OM. Is it page 29? Item 12. Guidelines for selection of assistant professor librarians in provincialized colleges of Assam. Annexure 3. Is this the one? Page 29.
Yes.
But this has been superseded by in 2022.
Where is that?
It is not on record, but it has been
Superseded.
superseded, so it has become automatically infructuous.
So this matter.
Do you have the details? We'll have to record it in the order. What is the details of the OM?
Right now, I don't have that the new lordship, but it has been superseded. They have already admitted. Petitioner has also admitted that.
When was it issued? 2022.
2022.
Can you don't you have the particulars?
I'll give it to the court master. Give me some time. I'll give it to the court.
All right. Who is appearing for the petitioner?
I can, lordship, can record my name.
This thing in item 12.
Yes.
Item 12.
Item 12.
Heard Mr.
T. Chakraborty.
P. Chakraborty, learned counsel for the petitioner. And Mr. H. Tahibildar.
A.R. Tahibildar.
A.R. Tahibildar, learned standing counsel, Higher Education Department, for the respondent, for the official respondents. Who serve the learned counsel for the petitioner submits that the office memorandum dated 8/11/20. What's the date? 2018, is it?
Yes. Page 11, 2018.
Which was challenged by the petitioner, amongst others, has already been superseded by another office memorandum issued in the year 2022. Stop further. In terms of the interim order passed by this court on 21/8/2019, the petitioner was allowed to participate, but unfortunately could not succeed. To stop, he therefore submits that the writ petition has become infructuous.
Yes.
Accordingly, the writ petition stands disposed of as infructuous. WPC number 5998/2019 be detached with the other bunch of writ petitions. Why you'll be one same writ petitions, okay? Then the last part I'll say detach. How did I start the beginning? Pardon, Mr. A? Okay, please Chakrabarti, petitioner in, please that WPC number 5998 of 2019. Top detection. You are there in the other case also.
Yes, sir.
Heard Mr. P. Chakrabarti, learned counsel for the petitioner in WPC number 3312 of 2021. Who submits that? The pursuant to the interim order passed by this court, on 21/8/2019, in WPC number 5998 of 2019, the petitioner was allowed to participate in the selection process for the post of assistant professor, is it? Assistant lecturer or professor? Assistant professor in the Department of Economics under the unreserved category. Stop. The petitioner, along with one Dr. Ajijur Rahman, was selected for appointment by the selection committee. But however, due to being overage at the time of application for the said post, the petitioner has not been appointed till date. Stop. The learned counsel submits that the petitioner otherwise has submitted an application for condonation of his age to the Commissioner and Secretary, Higher Education Department on 21/4/2021. But the same has not been considered. Mr. A.R. Tabhildar, learned counsel. No, before you cancel that. The learned counsel submits that in respect of the petitioner in this item 12, isn't it? No, item, who has been appointed?
Item 11.
Nirmala Devi.
Yes.
In respect of the petitioner in WPC number 2725/2022, her age has been condoned and she has already got the benefit of the appointment, unlike the petitioner. Next para, Mr. A.R. Tahibildar, learned standing counsel, Higher Education Department, submits that there is a general rule for relaxation of age as per the government notification white memo number AAP stop 34/50/27 dated 3/5/1951. And the petitioner may approach the respondent authority concerned with application for seeking condonation of age.
After examining Lordship, or can they say then the government will decide Lordship in terms of this, if she is entitled as per law.
Subject to the petitioner fulfilling all other criteria.
For
To
age
stop.
condonation. For age condonation.
For age condonation. To stop. The learned counsel for the petitioner submits that the petitioner had already submitted an application for age condonation, but if the court directs, petitioner shall file another application. To stop. Considering the submissions made above, and upon perusal of the materials available on record, the writ petition is disposed of by directing the petitioner to submit a fresh representation seeking condonation of age before the Commissioner and Secretary,
Before the secretary.
before the Secretary to the Government of Assam, Higher Education Department, within a period of 15 days from today, seeking condonation of age in view of being selected for the post of Assistant Professor, provide the report of the selection committee dated 12/10/2020. To stop, in the event of filing of such representation, the authority concerned shall examine the case of the petitioner and pass consequential orders within a period of 15 days thereafter.
As per the provisions of law.
By taking into account the provisions provided in this regard, with the above observation and direction, with petition stands disposed of.
Along with the order.
Mr. M.K. Sharma, Learned Counsel, appears for respondent number 3.
Lordship, that along with the or similar order has been in case of the other
No,
petitioner.
that cannot be, Lordship, that may not be as per in terms of provisions. By the way.
Okay, IA, in view of the order passed in the main writ petition, IA stands disposed of. Okay. IA 1836 of 2021. Yes, anything? None appears for the petitioner when the matter is called. For ends of justice, matter stands adjourned for 2 weeks.
That matter relates to correction of age. Due to mark, my lord, some revision has been pending.
You want to become younger?
Oh, yeah, my lord, Seva Secondary Board by
Huh?
Learned Council has appeared. Now, my lord, I have taken instruction, I have got an instruction today from my client that is approaching the authorities. So, my lord, 2 weeks, 3 weeks time may be given for adjourn for 3-4 weeks. Let me take the instruction of what.
On the prayer of the Learned Counsel for the petitioner, matter stands adjourned for 3 weeks
Taken by.
to enable him to obtain up-to-date instructions in the matter.
3 weeks time actually.
Yes, already given.
Liberty of like.
Allowed, yes.
May I please, your lordship? May I please, your lordship? Lordship, in this matter, lordship, I need some time for obtaining instruction. Lordship, the petitioner in the meantime has retired. The matter was pertaining to challenge in the constitution of an inquiry committee.
So what do you want? You want some time?
Yes.
3 weeks?
I need some 2 weeks time may be granted, lordship, because I have obtained instruction whether it's.
Similar order, huh? 2 weeks. You are right, but right, Mr. B. Chaudhary, Learned.
SCRT. Standing Counsel SCRT.
Standing Counsel SCRT appears for the respondent. SCRT.
Deeply obliged.
None appears for the petitioner when the matter is called. For ends of justice, matter stands adjourned for 3 weeks. Same order.
Lordship, in this matter, I am appearing for respondent number 225. We have been recently engaged as the standing counsel for the Teachable University. So, Lordship, a copy of the petition as well as the opposition and reply may be served.
Ask your friend. Mr. Your good name?
K. Jain on behalf of SCKL.
Mr. K. Jain, Learned Counsel, appearing on behalf of Mr. SCKL, Counsel for the respondent numbers
225.
225 submits that they have recently been engaged and therefore requires how much time?
Lordship, 3 weeks.
3 weeks time to prepare the matter. Mr. Your good name?
P. Khatonier.
Sorry?
P. Khatonier appearing on behalf of Counsel Mr. S. Borthakur.
Mr. P. Khatonier, learned counsel appears for Mr. S.
Borthakur.
S. Borthakur, who represents the petitioner and has submits that he has no objection. In view of above, matter stands adjourned for 3 weeks. Please give him the copy.
Lordship, our name should be reflected.
Have you filed Vakalatnama?
Lordship, memo of appearance we have filed.
How? Are you a standing counsel?
My senior is standing counsel. Lordship.
Or name of Mr. SCKL may be
Mr.
reflected.
Ethicals, standing counsel, Tezpur University.
Name of standing counsel?
Tezpur University.
Tezpur University reflected in the cost list hereafter.
Much obliged.
Yes.
In this matter, my lord, although matter in the year 2022, but after notice, my lord, this is come for first time, my lord. So I pray some time to file our affidavit as well as instruction, my lord.
3 years they got
My lord,
simple matter. A simple matter, Lordship. My post service has been commercialized. Somebody has challenged the staff pattern of the school. Not.
Let him complete the instructions, Mr.
lord.
Counsel. Your good name?
B. Talukdar.
Mr. B. Talukdar, learned counsel.
Standing counsel, elementary.
Learned standing counsel, elementary education, praised for and is granted 3 weeks time to obtain instructions in the matter and to file counter affidavit. List the matter again on so and so. Give a date. 24/6. Please file whatever you have to file.
Please, your lordship, as per last order, the department was supposed to obtain instructions. Lordship.
As per my instruction, my lord, here director has written to the secretary to the government of Assam Department of School Education regarding the release of refixation of area in respect of Janeshwar Borua. Here is my instruction.
What is the matter regarding?
Lordship, wrong fixation of.
Wrong fixation.
Wrong fixation of pay.
Non-payment of area salary.
Huh? Which one? Non-payment or non-fixation?
Non-payment of area salary.
Then what is this instruction?
So your director requested the secretary to sanction the said amount, madam. 5,74,964 against the Janeshwar Borua petitioner.
5,74,000. It covers your prayer.
5,52,000.
52,000. They're giving you more than.
Yes.
This is 74,000
74.
and plus 964.
Sometime maybe.
Your good name?
U. Sharma, madam.
Mr. U. Sharma, learned standing counsel,
Secondary education.
secondary education, by producing a communication dated 26/5/2025 of the Director of Secondary Education to the Secretary of the same department, submits that a sum of rupees 5,74,964
Yes.
regarding the arrear salary of the petitioner has been sought for sanction and therefore prays that he may be given some more time
Yes.
to come up with the up-to-date instructions in the matter.
This
In-
after 3 weeks, madam.
In view of above, list the matter again on so and so. Give a date. 24/6/2025. Copy of the letter produced shall be retained on record and marked as X for identification.
Much obliged.
May
Yes.
Lord, in fact, my lord, I am waiting for an instruction from the petitioner, my lord. 2 weeks time may kindly be granted, my lord.
Okay, as paid for by Mr. A.R. Buhia, learned counsel for the petitioner. Matter stands adjourned for 2 weeks to enable him to obtain up-to-date instructions from his client.
Oblige.
I beg your lordship, my lord, let us 17th grade 4 employees matter, prayer for regularization, my lord. In the meantime, some development took place, my lord. I have to apply this honorable court, my lord. That will come after 4 weeks.
Okay, your good name?
Take a Taludar.
Mr. A.K. Talukdar, learned counsel for the petitioners, submits that there are certain developments in the matter and therefore he prays that he may be granted 2 weeks' time. To
4 weeks,
obtain
my lord.
4 weeks' time
Different person.
to get up-to-date instructions from his clients. He prays aloud.
But, oblige, my lord.
None appears for the petitioner when the matter is called. For ends of justice, matter stands adjourned for 3 weeks.
Lordship, in this case, Social Justice and Empowerment Department has been implemented in
When?
case of WPT department.
When?
Because they are WPT department not in existence now. There is an IA that was disposed of, but the standing counsel is not shown over telephone. Can it be fixed after 2 days, Your Lordship? Their presence is required.
Respondent number 7.
Yes,
Newly.
newly implemented, and copies were also served. Issue is otherwise, direction was passed by this honorable court. This is the 4th or 5th time they have approached this honorable court. The direction was that the WPT visa department will provide a list of the beneficiaries who belong to the SC category as stipendary teachers supposed to be appointed. An amount of rupees 10,34,000 was
Anyway, let it be reflected first. Let them come.
Lordship.
Let them come. The standing counsel come. As paid for by the learned counsel for the petitioner. Matter stands adjourned to be listed again after a week. By showing the name of standing counsel,
Social Justice and Empowerment.
Department of Social Justice and Empowerment in the cost list.
No trouble. Everyone. This is your lordship.
Yes.
Lordship, the matter here is regarding the suspension of the headmaster, Lordship. The petitioner hearing the headmaster and he was placed under suspension. With regard to that, Lordship, the suspension order is at page 43. With regard to misappropriation of minority scholarship fund, Lordship, the allegation here.
All right. Then
Lordship, show cause notice was issued to him. Page 46 is the show cause notice.
what is the challenge here?
Lordship, he was reinstated in service, Lordship. He is
Okay,
again
good.
working as a headmaster.
Reinstated then?
Certain financial benefits are curtailed. And also the assistant teacher is now working as the financial DDO, Lordship. He's working as the DDO. The financial powers are curtailed from the headmaster, Lordship. Being the headmaster, Lordship, apart from that, the service benefits are also declined, Lordship.
Which order you're challenging? Any particular order?
Page 59 is the order.
But this is pending department.
Royal of departmental proceeding and outcome of CID-PS case number so-and-so.
Okay, now
CID-PS case number, the name of the headmaster is neither in the FIR nor in the charge sheet, Lordship. FIR I have annexed in the writ petition. I have the copy of the charge sheet. His name is not there, Lordship. There are some allegations on the basis of that they have suspended.
okay, any proceeding has been drawn against you?
No, Lordship, nothing has been done. And this is an order of 2022, Lordship. Until then, nothing has been done, Lordship. He has been reinstated on the basis of a report. They were satisfied with the report and he was reinstated, but the service benefits are curtailed from him, Lordship. That is the case here.
All right.
The long time of period has passed, Lordship.
Yes, what do you say?
Lordship, I am for the CID of the state, Your Lordship.
You're the CID?
Yes. Yes, Your Lordship.
So any CID case?
Corresponding to Honorable Court's order.
Lordship, the CID has been incorporated as a party pursuant to the order of this honorable court.
Okay, so any CID case against the petitioner?
So we were asked to carry out the necessary investigation, Your Lordship. Order to date to question.
Then?
Order.
So in the year 23 and
Instruction to 25 order that are
last order.
last order 25 court instruction.
Yes, so?
What we have found is that there sufficient materials has been found against the concerned petitioner, Your Lordship. That is has been specifically pointed out in the investigation that was carried out, Your Lordship. So we have discharged our part and we have comes to the finding. We came to the finding that the petitioner was involved in the anomalies, and it has been explained there properly in this.
So what is the next step?
So next step, since the petitioner's prayer with regard to his service benefit and everything. So in between, the direction was for us to carry out the necessary investigation. Accordingly, we have placed before Your Honor the findings that we had obtained. So let this be a part of the record, Your Lordship.
You file it. I'm not taking a paper like that.
That,
You are appearing for the CID, isn't it?
yes, yes, Your
You
Lordship.
can't file it.
Okay.
Then what next?
Then next, the concerned department, they will do their.
Concerned department, what are you going to do?
Lordship, we have not been served a copy of the thing. Let them bring it on affidavit, then my lord will.
That is a different thing, but you don't have any connection.
Get our instructions.
You don't have any connection with the CID people.
My lord, we'll get our instructions as soon as we get. Today, on the last occasion, my lord, the matter was last posted on 25/4/25, the 25th of April, and that on that occasion, my lord, the up-to-date status was called for by the.
Please write down.
CID PS case number referred to in the order, reinstatement order. Lordship, the name of the petitioner is not in the FIR nor in the charge sheet. Nowhere it is mentioned, not the
Alright.
name of the petitioner.
All right, all right.
Lordship.
Therefore, that they.
Case of the petitioner
2020.
is that after being reinstated into service, no, cancel that. Rewrite again. The case of the petitioner is that he or she,
He, Lordship.
he has been reinstated back into service after being suspended for some time, but service benefit has been denied to him on the ground that some CID case is pending against him. Mr. B. Diori, Learned Counsel, appearing for the respondent number
7,
7 submits that an inquiry has been conducted by the CID
6 and 7.
6 and 7. And it appears that the petitioner has some role to play in the allegation that has been made. In CID PS case number 1 of 2020.
In second para, it seems so, Your Lordship. CID PS case number 20/20
Second para.
of the first page.
On CID case, okay, CID PS case number 20 of 2020. Registered under section 120.
B, 120B.
406, 409, 419,
419,
428, 468, 471. IPC added section 66C.
There's some typing error here.
Yes, yes, that
in-
should be B.
Instead of 120B, it is 1208.
8.
120B, capital B, huh? Bracket, not bracket, sorry, slash 406 slash 409 slash 419 slash 420 slash 468 slash 471 IPC. What is this IT Act? IT Act also?
IPC, Lordship, the old act.
Information.
No, there's one
technology.
IT Act also here. written.
Information technology. Act.
Information technology.
Mm. Anyway. The learned counsel submits that he may be given some time to file the report by way of an affidavit. Praise aloud. Mr. A. Fukan, learned counsel appearing for the Department of Elementary Education, submits that he may also be given some time to seek instructions in the matter.
Lordship, I am appearing on behalf of the respondent number 3 director, Assam Minorities Development Board, as a standing counsel for the Welfare of Minorities Development Department. Lordship, we have been served a notice, and in the last order, Your Lordship, we have been asked for a report. But actually, we are not the appropriate party, Your Lordship, and respondent 5 and 6 have already, I think, submitted 7 also. They have submitted a report. So, Your Lordship, we have wrote a letter the CID, and till now we have not received any report from that from them. So we have not submitted till now.
A good name?
I'm S. Kashyap.
Mr. S. Kashyap, learned counsel appears for respondent number 3 and submits that the Directorate of Assam Minorities Development Board is not a necessary party in the matter.
We have also filed an affidavit of position regarding.
Be that as it may, the matter, the same shall be considered at the appropriate time.
Lordship, perhaps they are necessary because the.
I'm not saying anything.
Yes, yes, yes.
It'll be considered at the appropriate time. That's what I
Yes,
dictated. You file your affidavit, this
Yes.
thing, so that you can give a copy to the
Yes.
others, let them examine and.
Yes, yes.
Not of last one.
Petition.
List the matter again after 2 weeks.
Lordship, maybe after
2 weeks, 2 weeks.
4 weeks. 4
Why,
weeks.
why? Why?
If it is-
No, 2 weeks. You file it.
But a very small issue is involved in this petition, Lordship. Very small issue, Lordship. So what happened, Lordship, the husband of the petitioner,
Small issue. Can you finish it within 2 minutes?
Lordship,
Small issue, but we can,
try to
there's no
conclude
time.
Try to conclude within 2 minutes, Lordship.
How? How can you conclude in 2 minutes?
May I submit, Lordship?
What is the matter?
Medical reimbursement. The husband of the petitioner was an employee of Board of Secondary Education, Seva, Lordship. And he has undergone a bypass surgery, Lordship, in the year 2008. On 29/7/2018. At that point of relevant time, Lordship, Seva Health Regulation of 2016 was in force. And as per that regulation, Lordship, full reimbursement in connection to bypass surgery was, Lordship, payable. So accordingly, Lordship, the husband of the petitioner during his lifetime represented before a Seva authority, Lordship, but it was rejected, Lordship. And finding no alternative, Lordship, the wife of the deceased employee approached this honorable court by way of filing a writ petition, Lordship, 14815. That was disposed of by this honorable court, Lordship.
This is second round.
Second round, Lordship.
How it was disposed of?
Lordship, disposed of, Lordship, kindly have a look page 154, Lordship, operative party.
154.
154, page number.
Then?
As your Lordship got, there are 25, Lordship. Under such circumstances, since there is no denial by the board in respect of medical treatment undergone by the petitioner's late husband, it is directed that the board will re-examine the matter and after due verification of the claims made by the petitioner for medical reimbursement of expenses incurred for medical treatment of the petitioner's late husband, the board will grant ex post facto approval if required and thereafter reimburse the medical expenses incurred in respect of the treatment, including surgery undergone by the late husband of the petitioner.
Okay.
The respondent board may take recourse to clause 17, which provide for relaxation, if so required. And Lordship, subsequently, Lordship, height annexer 17, Lordship, page 158. The petitioner submitted the original bills to the SEBA authority for their consideration. That amounts to rupees around 7,04,000 rupees.
What is the full form of SEBA?
Secondary Education Board of Assam, Lordship.
Okay. Then
So original bill of rupees around 7,04,068 were submitted before the SEBA authority.
this is for what? Some surgery?
From surgery, including all cost, Lordship.
What surgery?
Bypass surgery.
Bypass surgery.
Coronary artery bypass grafting.
One surgery.
One surgery.
One.
Lordship. And subsequently, the deceased husband of the petitioner was admitted due to secondary infection, Lordship.
He expired.
He expired due to COVID-19 in the year 2020, Lordship.
And now claimant is the wife.
Wife. And height, Lordship, annexer 18 impugn order, rupees 3 lakhs has been sanctioned by the SEBA authority.
Okay, out of 7 lakhs. So balance of 4 lakhs. Balance of 4 lakhs. Then
So Lordship, pending no order authority, the petitioner has approached the petitioner
Again.
seeking a mandamus, Lordship, to pay the entire amount
Okay.
of rupees 7 lakhs. And
3 lakhs already paid, and the balance is 4 lakhs.
4 lakhs.
So under on what basis you'll be paid 4 lakhs? Tell me.
Lordship,
Page
Lordship, SEBA health regulation, Lordship, kindly have a look, annexer
The next year,
11,
page
page 50, Lordship.
50.
It starts from page 50.
So as per the direction of this court, in the earlier round of litigation, your thing was examined and they found that you could be given only 3 lakhs.
3 lakhs.
Kindly have a look, page
So
61.
how do you say that now again they'll review that?
Have a look, page 61, Lordship, for a moment.
61.
61. Has Lordship got?
Yes.
Full reimbursement of expenses of the following type of treatment may be allowed, subject to submission of certificate from authorized medical attendants. Following are the types of disease, Lordship. Number 6,
Okay.
bypass surgery. So full
Okay.
reimbursement, Lordship.
This is what, SEBA?
Have a health regulation, Lordship.
Then why did they give you 3 lakhs then?
But the SEBA authority set abhorrent appeal upon the order passed by your Lordship. Your Lordship is directed to re-examine the matter and to reimburse the same.
So where's the order? That they'll get only 3 lakhs.
Lordship,
Any order was passed?
by the
SEBA.
Yes, my lord.
impugn sanction order, Lordship.
161.
Page 160, Lordship, annexer 18.
No, this is sanction only.
Right.
Where is the decision taken?
Decision taken, Lordship, they have filed affidavit in opposition, Lordship.
This is only the outcome of the decision.
Lordship.
We want to see the decision. Anything there, Mr. Shutia?
Yes, my lord.
Where is the
Lordship,
decision?
Kindly see
You are
our-
appearing for SEBA also?
Yes, yes. Lordship, kindly see our affidavit, my lord. Affidavit, our regulation, my lord, page 167. Boards minutes is, my lord.
Full reimbursement.
Yes, my lord.
Then why didn't you give full reimbursement?
Yes, my lord. In page 167, agenda number 10, to discuss the matter of reimbursement of medical bills submitted by Suja Begum, wife of so-and-so, ex-assistant controller SEBA regarding so-and-so. Now, question is, my lord, the petitioner was a ex-employee. So, Lordship, kindly see page 174. This is a ballot amended ballot regulation. Lordship, kindly see the board medical attendance regulation 2016. It's with effect from 1/1/2019. Lordship, kindly see page 176. There's a limitation, my lord.
This is amended regulation, Lordship.
Yes,
This has
amended
come into
regulation.
force in 2019, Lordship.
No. A limitation and reimbursement medical expenses.
Where?
Lordship, kindly see page 176.
Yes.
9. For recommendation in private hospital, nursing home of the state and reimbursement expenditure incurred by the patient shall be
Nine.
subject to maximum rupees and not below the as per grade so and so so and so. And C, the maximum reimbursement of medical expenditure subject to the maximum limit as stated herein. For employees, those who are working 5 lakhs and ex-employees, dependents 3 lakhs.
Okay.
So according to this regulation, law, we have paid it.
Just a
And
minute.
beyond that, C is
Let him
not
finish.
entitled. Because, my lord, board is a self-funded institution. The board only earning only the student fees. Board is an independent body, autonomous body, it is not funded by the government. So we have to think about the expenditure, all these things, my lord, carefully handle it. So as per our amended regulation, my lord, he is entitled to 3 lakhs, we have paid it.
This is amendment.
Yes, amendment. Even though he is not entitled because the board, every institution has a panel hospital, but he did not go to a panel hospital. First round of litigation. However, first round of litigation court has said, so forget it, panel hospital, you examine it, whatever amount is entitled, you paid.
Okay, this amended regulation is effective from which day?
1/1/2019.
Huh?
1/1/2019.
1/1/2019.
And he submitted his application 27/6/2019 after 5 months. That already this amendment is.
From where you're saying 1/1/19?
Yes, page 48.
Huh?
Page 48 is petition.
No, this starts from page 174, annexure B.
174 is our amended regulation. With effect from regulations are come into force with effect from 1/1/2019.
Okay, from 1/1, okay.
Yes, and left petition page 48. He
Hmm.
submitted his prayer method for reimbursement on 27/6/2019. This amendment has already been effected. So petitioner cannot claim it, my lord. Even in the insurance company also, whenever we file a bill, my lord, where the insurance company paid full amount. There is a some, my lord, repetition. This is a self-funded institution, my lord. Only the fees of the students board is running. So it is not funded by the government. So beyond that, we cannot expect because he's an ex-employee.
That's a different thing. Then why do you make regulation? You make regulation also.
Yes, regulation.
For refund.
Yes.
So you go by that only. Source of fund is a different chapter.
This separate chapter. No, that's
You have given some guidelines that you can get mismatched.
Yes, regular page 176. Yes, the slab is there, my lord. How expenditure will be paid to a employee and an ex-employee. Apparently, well, a petitioner is an ex-employee. And his wife has claiming this monetary reimbursement. So reimbursement, there is a limitation.
So what to do?
In this regard, may I submit a judgment, Lordship?
Don't submit judgment, you just submit
So the law.
orally first.
Well, said, Lordship, scheme should be considered prevalent at the time of operation, Lordship. In 2018, rules of 2016 were applicable, Lordship. So I'm entitled to get full reimbursement, Lordship. Amended rule will not come in any way.
No, this is a different thing, my lord. When he was in the ill, where he submitted the bill, that will be affected. He is ex-employee, my lord. And he did not go for penal hospital. Definitely our penal hospital, suppose my insurance penal hospital says the city health, downtown, GNRC so and so. He excluding that penal hospital, he took the medical responsibility in another hospital. Even though court has passed this order in the earlier litigation, you consider it.
Then why did you give him? Don't give him.
No, why we cannot pay? How can we pay this? As per
Don't pay him 3 lakhs also.
we have paid 3 lakhs already.
Since you're not gone to the panel hospital, we cannot give you. Take your stand.
Learned friend is making complaint, Lordship.
But you have given 3 lakhs.
Yes, we have already given.
Anyway, we'll not take up the matter today. We'll have it some other day.
Lordship, may take it as part of Lordship.
No, not part of.
Lordship, has
When?
invested
When will
sufficient
list
time.
it?
Lordship.
When? Mr. Chuti?
After 2 weeks, man.
2 weeks.
A date may be fixed, Lordship, because it is very tough.
Straightforward by the parties, list the matter again on so and so. 17/6.
76. Obliged.
Not so bad, Lordship.
How many is left? Okay, let's complete it. We'll give a date basically. We'll give a date for the remaining cases.
We're supposed to file affidavit, Lordship, 33.
Item 33.
33.
Who is appearing for 33?
Okay, Lordship, for petition.
No, for respondent.
DS now was appearing, Lordship, DS now.
We'll give them some more time then. Further 2 weeks' time is granted to the respondents for filing their affidavit. Item 33.
Much obliged.
35.
May I please talk?
Hmm.
In this case, my lord, the petitioner husband has died while working as a headmaster, my lord. The petitioner
25
pay
matter,
for-
my lord, I need some time for instruction.
As paid for by the learned
Standing
counsel,
counsel, elementary.
standing counsel, elementary education department, Mr.
B Talukdar,
B. Talukdar. Further 2 weeks' time is granted to obtain instruction on the matter.
obliged.
In this case, my lord, the finance were asked to obtain instructions.
Yes.
My lord, I'm seeking some further time of 2 weeks. Here, my lord, the respondent number 3 and 6 have taken a stand in their affidavit that, my lord, a file was sent to the finance department which was rejected.
Hmm.
To that extent only, my lord, I need to produce the instructions before the honorable court. We have already sent the communication, my lord, they are seeking.
How much
some
time?
My lord, lordship will kindly accommodate me for further 2 weeks, my lord.
Okay, as paid for by Mr. R. Borpuchari, learned standing counsel, finance department. Further 2 weeks' time is granted for obtaining instructions in the matter.
I'm
List
so
again after
obliged.
2 weeks. 55, anyone?
It will take some time. So maybe taken up, my lord, in the 4th week of June, because I will be out of Guwahati.
All right.
4th week of June. I
As
have
paid
told
for
my
by
lord.
Mr. R.C. Saikia, learned senior counsel appearing for the petitioner and not objective to the by the side. List the matter. You want a date?
On 26th June, my lord.
By Mr.
26 June, cannot be report to
One
some
sec-
extent.
One Asakuha will be outside Assam.
Outside Assam.
So I have taken the date on 26th June, so a good number. of
Online,
cases.
online, he can do.
Let it come, madam, on 26th June. We will do the case.
26 is okay?
When you want.
List the matter on
He's
26.
a very powerful man.
My mother, he is my old friend.
26/6/2025. So I don't know who is more powerful. The fate will be decided on 26th.
Obliged, Lordship. Much obliged.